Hey, welcome everybody. Welcome to today's Law of Self-Defense show, a very special show indeed, because we're doing some live trial coverage, impromptu, unplanned, unscheduled. So we're kind of pulling it together at the last second. Indeed, as First Last says here in the comments, we don't even have the mods on board yet. We'll have to see how that goes. Of course, the trial we're covering. Oh, for those who don't know, I am, of course, attorney Andrew Branca for Law of Self-Defense, if I can remember my last name. So the trial we're covering is the murder trial of Aaron Dean. Aaron Dean was a Fort Worth police officer back in 2019, and on October 12th of that year, at roughly 2:30 in the morning, he was called out to do basically a wellness check on a home. A neighbor of the home, and again, this is 2:30 a.m., a neighbor had noticed that the front door of the home was open, all the lights were on, which was unusual in that neighbor's experience. So they called the police to come investigate. One of the responding officers was Aaron Dean. And while he's walking around the outside of the home with his flashlight, he sees through a window someone inside the home holding a gun. And he shouts at that person to drop the gun, and then he fires a single shot. And that single shot killed Atatiana Jefferson, 28 years old, who was babysitting her nephew inside the home. A gun was recovered. So this was not the officer's imagination that he'd seen someone with a gun. But within 2 days of that event, he had been charged with murder. And within 4 days of the event, he had resigned his position with the police department, something along those lines. Let's see, when was he charged with murder? Yes, October 14th. So 2 days after the event, he resigns his position and is charged with murder in the killing of Atatiana Jefferson. Now, this was caught on body camera footage, on body camera. I have that video. I'm going to share it with all of you. There's nothing grotesque in it. Frankly, it's not very good video footage. You can't really see much of what's going on. The officer's flashlight is reflecting off the window, so you can't see well through the glass. Perhaps he couldn't see that well through the glass either. I don't know. But I'll play that for you momentarily so you can see that body camera video. Now, we are live covering the trial, meaning I'm live doing it. We are playing catch up with the trial itself, though. The trial started early this morning. And we're several hours behind the start of the trial. So we'll be going through the trial in catch-up mode over the course of today. And if it seems worthwhile, we'll be continuing our coverage in real time tomorrow. The nice thing about playing catch-up mode is we can skip past the breaks, and we can play the video stream at something faster than 1x to expeditiously move through the trial process. Before we jump into that body-worn camera footage, I do want to mention, of course, our sponsor for today's program, which is none other than our own American Law courses. These are courses that you can take to learn the law at a law school-like level without the cost, time, or politics of going to law school. Now, these are not accredited in any way. You're not going to get a law degree at the end of this, but it's for your personal knowledge. And of course, it's, again, a fraction of the cost and time of law school, and without the toxic politics that pervade law schools today. We just finished up our first course in the American Law courses, Criminal Laws, taught by none other than our own attorney, Steve Gosney. It's been extremely well received by the students. And the last class in the criminal law semester is this week, actually, and then the students will take the final exam, and that'll wrap up the fall semester for American Law courses. We are running 2 additional courses for the spring, one on property law. Let me pull that one up so you can see it. Let's see. Where are you, property? Here we go. Here's the property law course, taught by none other than our good friend, Andrew Esquire. And we're going to be covering property law on a semester-long basis, much like it's taught in first-year law school. Right now, we're still in the pre-registration period, so you can benefit from saving over $1,000 if you register for that course now. You can learn more about it at lawofselfdefense.com/property law. And here, Andrew and I talk about what you can expect to learn in the course of this property law class for the spring semester. These are all taught live, by the way. They're streamed live to you at your computer, generally 14 classes over the course of a semester with an optional final exam at the end for certification. We do have a certification if you pass the final exam. Then we also have, in addition to the property law class this spring, we have our evidence course being taught by attorney Ryan Ballinger. This is going to be a great course on the rules of evidence. Evidence law, we call them the guardrails of justice. It's these rules of evidence that determine what quality of evidence will be presented to the jury, what evidence will be excluded from a jury, why lawyers object to these things, why objections are important, different classes of evidence, circumstantial evidence, direct evidence, expert witness evidence, hearsay evidence, and why it's normally excluded, what are the many exceptions to hearsay, and much, much more. And you can learn more about this course at lawofselfdefense.com/evidence law. Again, in the pre-registration period right now. These courses start the second week of January, and then it'll be at the normal price. So if you're interested, now would be the time to look. lawofselfdefense.com/evidence law for the evidence law course, and lawofselfdefense.com/property law for the property law course. Okay, so let's get to this body-worn camera footage. Now, there is a shot fired here, but there's no gore. That's not included. So there's nothing that should, of course, will be demonetized immediately. That's the way these things go. But I thought it important enough to our understanding of the case that we share it even before we start tracking the trial proceedings, because this is essentially what happened. So again, it's 2:30 a.m. The officer, Aaron Dean, has been called to the home to do effectively a wellness check. Presumably the neighbor who made the call to the police was fearful there might be a robbery or home invasion going on. So the police are approaching cautiously. Aaron Dean's moving around the home with a flashlight. And at some point he looks through a window in the home, sees someone on the other side of the window holding a gun. And that's when the events transpire. This entire video is less than 2 minutes. Really nothing happens until the last few seconds, but I'll play the entirety of it so you can say you've seen the entirety of it. Here we go.
Put your hands up. Show me your hands.
So there's a still image of the gun that was recovered, and they have a second image of the gun, a little bit clearer. It's not clear to me. It says still frame. I don't know if this was supposed to be captured from the body-worn camera. I suppose so. So that's the body-worn camera. That's how that went down. Now, keep in mind, so he's been charged with murder. and presumably his legal defense is going to be self-defense. And when we do a self-defense analysis, it's from the perspective of the shooter. It's not necessary that the person who was shot was actually doing anything wrong. In fact, as far as I know, there's no indication that Atatiana was doing anything wrong. She was babysitting her nephew. That doesn't, and so this is a terrible outcome. I think we'd all agree. 28-year-old woman, and of course it shouldn't matter, but this is the world we live in. She happens to be black. The police officer here is white. So we have that dynamic. Of course, we have all the usual protest and Benjamin Crump types circling in the waters. But there's no indication to my awareness that Tatiana was doing anything wrong or that would deserve getting shot. But that's not the legal question. And we have a bad outcome here. And often when there's a bad outcome, people want there to be a crime underlying the bad outcome, some way to respond with the criminal justice system. Someone should be held criminally responsible. But the truth is, awful but lawful shootings happen all the time. And the law doesn't require for a use of force in self-defense to be lawful that the defender was making perfect decisions. The law doesn't require us to make perfect decisions in self-defense. It requires us to make reasonable decisions, which means, did we have a reasonable perception of an imminent deadly force threat towards ourselves when we use that force in self-defense? And probably the answer here on this superficial level, based on this body-worn camera, is that this was a lawful shoot in self-defense. Remember the elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. We have our usual cheat sheet, folks. It's still free, doesn't cost a penny. It's a PDF download, lists the 5 elements of self-defense, and provides a brief explanation of each. You can get this at lawofselfdefense.com/elements. When we do this use of force analysis, we're looking at those 5 elements. The state would have to disprove one of those 5 elements, any one of them, beyond a reasonable doubt. So let's consider them. Innocence. Well, that just means, was the officer acting unlawfully? Well, he wasn't. He was acting in the lawful performance of his duties. Perhaps a stranger, a non-law enforcement officer, might have been trespassing, but this officer was present because he was responding to the wellness check call. He was acting under exigent circumstances. He wasn't acting in an unlawful manner at any time up to this event, I guess arguably besides the shot itself. But leading up to the decision to use force, he's got the element of innocence. What about imminence? Imminence meaning the threat you're defending yourself against can't be some past threat or offense. It can't be some speculative future threat that may never happen. It has to be a danger that's either actually occurring or imminently about to occur. Well, here the officer presumably will say he saw through the window someone just a few feet away with a gun in their hand, raising the gun at him. Well, that's an imminent threat. So we have innocence, imminence, proportionality is the intensity of the threat. Was it a deadly force threat? Well, a gun was involved, so that's a deadly force threat. There was a gun in the other person's possession, presumably being raised at the officer. Then we have avoidance. While an officer in the performance of their duties doesn't have any legal duty to retreat. In any case, this happened in Texas, Fort Worth, Texas. And Texas is not only a stand your ground state, it's a hard stand your ground state, where the jury is instructed that they are not to even consider the possibility of retreat in deciding whether a use of defensive force was reasonable. So avoidance is really hard off the table in this jurisdiction and on these facts. And finally, reasonableness. Was the officer's perception of an imminent deadly force threat the perception of, first of all, did he subjectively believe it, genuine good faith belief he was facing that threat? And second, was it objectively reasonable? Would a reasonable and prudent person in his position have perceived the raising of a gun in his direction as an imminent deadly force threat? The answer is almost certainly yes. So the case for the prosecution here is not particularly strong based on the facts as I currently understand them, as I've currently shared them with you. That doesn't mean Atatiana Jefferson did anything wrong. But if that's the question you're asking the wrong legal question. The question here, the correct legal question is, did this officer, while otherwise acting lawfully, reasonably perceive an imminent deadly force threat towards himself? If he did, he's privileged to use deadly defensive force in defense of his life under those circumstances. But here he is. Of course, he's facing a murder charge now, a murder trial. If he's convicted, he should expect to spend the rest of his life in prison without possibility of early release. And again, I want to reemphasize again, none of this is to suggest that Atatiana Jefferson did anything wrong or deserved to die. But those are not the correct legal questions in this trial. All right, so let me pull up. By the way, let's see if this has been. Give me just a second. Sorry, folks, we got a bunch of plates spinning all at the same time. Again, there we go. All right. Yeah, it's also not the right question is, did Tatiana have a right to have a weapon in her hand herself? Is it possible she reasonably perceived there was a deadly force threat outside her home and was privileged to arm herself with a gun and even point the gun at the person she saw outside? Yes, that could all be true. That can be true. But that's not the right legal question. Both people can be legally privileged to use deadly defensive force in the same moment. You can have a case where both people are not privileged to use force, like a case of deadly force mutual combat, where it's two bad actors. You can have a case where one is privileged and the other is not. You can have a case where both parties are privileged to use deadly defensive force. It happens all the time, and that may well be the case here. And because we have a bad outcome, it's very easy to armchair quarterback the situation and say, well, he should have done this different. I should have done that different. That's always the case, folks. That doesn't make what he did a crime, especially if he's going to have evidence that consistent with his training and experience, that's not what he would have done. If you think there's a home invasion, a kidnapping, a domestic, any of those things could be happening with the doors wide open at 2:30 in the morning, sufficiently unusual that the neighbor called for a wellness check in the first place. So we will see. We will see. So let me pull this up. Pull up the trial. Now, I don't have the names for all the people involved yet. Again, I didn't want to take the time to do that while the trial was taking place, but I'll do it as things are going on, as we have little lull spots. Of course, the defendant is Aaron Dean, the victim, Atatiana Jefferson. The judge is George Gallagher. Now, this case has taken a couple of years to come to trial, right? This is now December 2022. This happened in October 2019. Some of that was COVID. Some of that was just murder cases can be complicated and take a lot of time to prepare for trial. But also, the original judge on the case was actually removed from this trial because of accusations of bias against the defendant and against the defendant's legal team. It's also perhaps noteworthy. I mean, probably not. This is Tarrant County, Texas. But it's probably noteworthy given the racial dynamics that are inevitable around this case, that the 14 people picked for the jury, 12 jurors, 2 alternates, are all white. So of course, I'm sure that'll get big coverage in the media. That's not actually unusual in Tarrant County. One would not be surprised to get an all-white jury there, but that's what we have in this particular case. All right, so let's see. I'll pull up the stream, and we can get started on this. So again, we're playing catch up with the trial. So this is from this morning. This is several hours behind, and we'll speed through the breaks, and we'll play it at a faster than normal speed as opportunity allows.
regard to
Objection for purpose.
Okay,
All right, good morning, everybody.
here we go.
Mr. Gill, it is my understanding that the defense has some matters that it wishes to place into the record regarding the pending motion to change venue. Is that correct? Go ahead.
228, 229, 230, 228, 229 are recent editions of the front page of the editions of the Star Telegram, and 230 is a DVD containing a number of recent news stories from local media outlets, a lot of which were provided in discovery by the state.
State have any objections to, for purposes of this hearing, to defendant's exhibits 228, 229, and 230?
So these are all news
No
articles
objection
about the
for
trial.
purposes of This hearing to defendants exhibit 228, 229, and 230.
All right, they're admitted.
And yes, folks, if you could please, if you're watching this on YouTube, please subscribe, hit that like button. If you're watching on Rumble, where we're also streaming, please do whatever the equivalent for that is on Rumble. That would be appreciated.
Do you have any additional evidence that you would wish to offer in regard to the motion for change of venue?
We do not, Your Honor, rest on the motion.
Does the defense have any evidence that it wishes to present in regard to the motion for change of venue? Any additional evidence?
No additional evidence, Your Honor. The state would, the main evidence the state has would be the panel's response during voir dire last week.
Does he desire any argument, final argument on the motion for change of venue? Defense?
We can brief the judge, we waive our right to open and reserve our right to close.
Mr. Smith? And I have the state's bench brief that was furnished to me previously.
They say they waive the right to
good morning.
open by the defense.
Just briefly, as you mentioned, the state filed a bench brief, just to highlight some of the points in that the defense has a heavy burden in a change of venue motion to either establish that the prejudice in the community was pervasive, prejudicial, or inflammatory, or under the second prong, that there was a
Well, it certainly was.
force that was
Lots of protests.
Their trial in this county.
Lots of the typical kinds of biased news coverage.
Pervasiveness of the prejudice or of the media. Most coverage of this case was in the immediate aftermath of the offense. Since the offense, the coverage has been near case updates and included the original information that was provided in that original coverage. Additionally, there's been no indication of the viewership of the vast majority of the media coverage that the defense has offered into evidence. There's been Star Telegram circulation numbers, but we have seen the evidence has been from other news sources and things like that, with no indication of viewership. Without that, there's no way to know how many people in the community have actually.
Someday these lawyers are going to learn how to use microphones.
The jury panel last week and the benign panel truly showed that the pervasiveness of the media attention in the county is not as high as the defense would make it seem. When we compare the numbers of the benign panel that had heard of this case to
Her voice is
other
shaking.
cases, specifically the Gonzalez case, which was cited in the state's brief, 57% of the benign panel had heard of this case before, which is really in line. In Gonzalez, the Court of Criminal Appeals noted cases with 67%, 63%, 61%, and 81% where the benign panel had heard of the case, which is very in line with what we have in our case, in fact, even more so. And out of that 57, about 25%, and that number is even a little high, of the benign was dismissed based on their exposure to pretrial media. And it's within this court's discretion to believe the jurors' assurances out of those who were questioned regarding their pretrial media exposure, that they did not have preconceived beliefs or beliefs that they could not set aside in rendering a verdict in this case. Based on just the number of the benign in this case and the media, the evidence just does not demonstrate that pretrial media publicity has been pervasive. In regard to the prejudicial and inflammatory prongs of that first 31-3 claim, when media is accurate and objective, that goes against a finding of prejudicial and inflammatory, and that's largely what we have in this case. The media coverage of this case has been just that, accurate and objective, reporting on the facts.
That would be unusual.
And the case updates, what the trial proceedings that have occurred in this case. In addition, although the body camera has been released to the media, that is evidence that the jury is going to see. Case law, as mentioned in our bench brief, supports the fact that when it is evidence that is going to be presented and it's done in an objective, accurate manner, then that weighs against finding prejudice and inflammatory. The media attention in this case has not been pervasive, has not been prejudicial, and has not been inflammatory. The law does not require that jurors be completely blind to the fact that this offense occurred, merely that they be fair, and that's what our deny panel showed that they are going to be able to do. So we would ask that the court deny the change of venue motion on that first prejudice of the media prong. In regard to the dangerous combination, which was raised in the supplemental bench brief, the Ricer case, that we cited in our bench brief, is strikingly similar to the facts of this case and demonstrates that in order to justify a change of venue based on a dangerous combination, it's not just that community leaders spoke out about the case or maybe even spoke to each other about the case. It really, the defense has a heavy burden again to show a coercive force that could influence the proceedings and the right to a fair
Folks,
trial.
for questions, and I see some good ones being posed. If you want your questions answered, on YouTube, they need to be super chat, $5 minimum. Or if you're a law self-defense member, we're, of course, streaming this on the member dashboard. We'll answer your questions there at no cost to your members. For those of you paying to get questions answered as super chats, I think would be much more cost effective for you to become a law self-defense member. It's less than $10 for a month, folks, and you get all your questions answered. That would presumably be the entirety of this trial, for example. But if you don't want to become a law self-defense member, you could do the super chats. It'll be more expensive. To become a law self-defense member, point your browser to lawselfdefense.com/join.
Number one, the majority of the publicity of this case did not occur at or around the time of the event. The coverage has been steady and pervasive throughout the 3 years that this case has been pending. Every single event that has occurred at this courthouse has been widely covered and widely publicized, including routine court settings, including the change of venue motion and testimony itself, up to and including last week with the death of Mr. Lane and the beginning of jury selection. All of those matters have been widely publicized.
Yeah, so the lead attorney for this defendant died last week. Jim Lane died November 28th, just a few days ago, and he was lead counsel.
That shows the number of households that are reached by their news broadcasts. We were stonewalled by the other media outlets in Tarrant County to get that information, but you can also see from the pervasive nature of what the actual Benaire members in this case saw, that the coverage
died of old age, 78 years old.
Previous finding in this case that the coverage was both pervasive and prejudicial. That finding was made by Judge Hagerman last summer, even before the recent news coverage, the recent spate of news coverage. Also, the coverage has not been accurate, and the coverage has not been objective. And that goes to the inflammatory nature of the publicity in this case. It's been inflammatory and it's been prejudicial because most of the news coverage has been inaccurate. Most of the news coverage has said that Aaron Dean went out to his home on a welfare check, which is absolutely and totally wrong. The news coverage has had the mayor and other leaders of Fort Worth standing up in front of them, which have been, these news conferences have been shown time and time again, saying that the weapon possessed by the complainant in this case was irrelevant, and they don't know why that is any part of this case, which is going to be a major part of the case. There are a lot of other factual inaccuracies that we see as we go through the coverage in this case, and you will see, and you have seen when you review all the news coverage that's been introduced by the defense in this case. The news coverage has also been extremely emotional and presented from the standpoint of the complainant. It's all been about the family waiting for their day in court. And I'm not saying any of this is wrong, but that's how the coverage has been. The coverage has always been told from that standpoint, about the community standpoint, about justice for Atatiana. It's been drilled into the heads of the Venire that way. And it's been presented in a racial aspect of it. It's been presented and emphasized. It was a white officer that shot an African-American female. And all of this is presented time and time and time again until it's become a theme and a mantra of all this coverage that has continued until this very day. Under the dangerous combination prong of the change of venue statute, 3103 of the Code of Criminal Procedure, we have shown you that the mayor and the chief of police and the city councilman, all widely publicized, have taken, at least the mayor and the chief of police have taken what they knew to be the truth and twisted it and made a presentation to the public that is different from what they knew the truth to be. And that has all worked to the detriment of Aaron Dean. And that is dangerous, and it's a combination of individuals that did that. A combination of influential persons. There's no one more influential in the city of Fort Worth than the mayor of Fort Worth and the chief of police of Fort Worth and the councilman of the city of Fort Worth. And we also presented you testimony.
That's Aaron Dean on the far right of the image there,
was involved in making sure this case got moved along.
sitting down.
And that the case was presented in the light best, the light shown by the mayor and the chief of police. So the coverage has been inflammatory in that regard. It's been inflammatory on the racial and the factual inaccuracies that have been presented to the public. And we saw how much that pervaded the jury panel. When
500 people watching, only 200 likes, folks, on YouTube. Hit that thumbs up, please. I would greatly appreciate it. They're free. The thumbs up are free. The likes are the most powerful factor YouTube uses.
They were concerned about security.
On Rumble, 154 watching, only 8 Rumbles. Hit that plussy if you're watching on Rumble.
I have never seen a jury raise their hand and ask about security for a case and how they're going to be kept secure by the court. That was a major thing that was on the minds of those jurors, and they didn't get that.
Yeah, I've got the volume
by walking in this
cranked up as high as I can, folks.
You heard the testimony of Dr. Galusha, who testified that this is the kind of thing.
Yeah, I'll email Steve.
Remains in their subconscious. So
Attorney Steve Gosney.
That did not raise their hand on Monday and say they heard about the case. As Dr. Galusha testified to you, they may be telling the truth. They may honestly believe they haven't heard anything about the case. But psychologically, if they're members of this jury and they're deliberating on the case, according to the studies that Dr. Galusha presented, those facts begin to creep out of their subconscious and enter into their deliberations to the point that the facts that they heard in pretrial publicity take precedent over the facts they hear at trial. It's the first in, first out rule. What they have heard, the primacy of what they heard first takes precedence over what they hear later on, and then they match the testimony that they hear in the courtroom to what they heard in pretrial publicity to confirm what they heard in the pretrial publicity, and then use that during their deliberation. As I mentioned earlier, what they heard in pretrial publicity is inaccurate and not correct. So just because we have a fair juror or a jury seated in this case does not mean we have a fair jury. This case has been permeated with publicity, inaccurate publicity, inflammatory publicity, and even in light of the fact that there is going to be a jury that's ready to come out here and take a seat in the jury box and begin hearing testimony in this case, there's no guarantee under the Sixth Amendment that this is a fair and impartial jury. And we would ask that the court move venue to a place that has not been subject to pervasive publicity, pervasive, inaccurate, inflammatory, prejudicial publicity that this jury has been subject to.
Your motion for change of venue is denied. You may have a running objection throughout the trial to the jury. It is my understanding the parties have furnished the state's disclosure of documents that both lawyers have signed. Is the state's satisfied?
We are.
Defense is satisfied?
Yes, Your Honor. I believe I did the full copies of the files.
Oh, it has been filed?
Yes, sir.
Okay. Are there any other matters that we need to take up? The jury is present. Is there any other matters we need to take up before we bring them in?
Yes, Your Honor. The state would just like to put on the record that the court doors were open at approximately 8:30, I believe, between 8:30 and 9 o'clock this morning, and that the doors were open for anyone that stood in line to come in. There was the public, the gallery is full, so obviously it is an open court. And for the record, Your Honor, how many other courtrooms is the audio and video being piped into for closed circuit purposes?
There is a courtroom next door that is, excuse me, receiving a live feed, and it is open to the public. In addition to that, there is a second courtroom across the hall that is available for media, for the media folks. It is also open to the public, but it looks like Mission Control in Houston when you walk in there, so.
And so that's 2 extra courtrooms for the public to enter. It would also be considered open courtrooms for purposes of the law and code of criminal procedure. Your Honor, also, there's an agreement between the parties for the rule under 3603 in the code of criminal procedure. Family members as defined in the code, sisters, brothers, are allowed to come in and sit and watch the trial, even though they may testify at a later phase. We've represented to the defense that both one of the sisters and a brother of the victim may be testifying at certain phases of this trial. However, that testimony would not be materially affected by the evidence they may hear in the case in chief, and they'd be testifying not about the offense itself as it happened. And there is an agreement with the defense for also the defendant's, I believe, mother and father and sister to be in the courtroom, to be excluded from the rule as well.
Is that correct?
We don't need the code of criminal procedure. Dale and I are following that.
All right. Thank you, counsel, for that.
And
Mr. Smith.
yes, Your Honor, the last thing is the state would
I guess that's Dean's family there.
on the toxicology results of Atatiana Jefferson. At this point, anything that was found in the toxicology result would not be relevant, and we would ask that the defense approach, and we have a hearing outside the presence of the jury before any of that testimony is in front of the jury, so therefore we can determine its relevancy and admissibility.
For limiting purposes only, is there any objection?
No, Your Honor.
Okay. Y'all just approach if we feel like we need to talk about that.
That's all the housekeeping matters.
So I guess she was on drugs. not that I think the state's quite right here. It shouldn't
404B notice.
be relevant.
Any objection for limiting purposes only in regard to 404B?
For the punishment evidence, no, Your Honor.
Yeah, I'll try to lower my mic.
Happened on October 12, 2019.
Thanks.
Defense motion is granted. Y'all approach the bench if you feel like you need to talk about it.
Yes, Your Honor.
And to be clear, we're asking that this motion pertain to all phases of the trial.
Understood. Yeah, so if there's anything in regard to 404B, approach the bench.
Yes, Your Honor.
Okay.
Anything on the notice, Judge.
Yeah, on their notice, yeah.
And also, we would ask for a motion limiting on any victim closure or victim impact evidence at the victim's phase of the
So
trial.
404B is character evidence, prior acts
Any
evidence.
objection to that for limiting purposes only?
Not for limiting purposes only, Your Honor.
All right, that's granted.
Your Honor, I have nothing else.
Ms. Ford, will you be staying with us or are you leaving?
I
And
believe council table.
the only reason I ask is we were going to have to figure out how to get folks in. If you would return your chair over to the jury box. And thank you, I appreciate your remark.
Thank you, Your Honor.
Both sides ready for the jury?
State's ready. Defense is ready.
All right, here comes the jury.
Karen? I don't know where Brian went.
I don't think the drugs are relevant here because it doesn't appear that Atatiana Jefferson was acting in a manner that would need to be explained away by drugs. She probably legitimately thought she was dealing with a prowler outside her home.
Everyone may be seated.
8 men, 6 women on the jury,
Good morning.
all white.
Everyone stands as you come into the jury box, but once you come into the jury box, just have a seat. There's no need for everybody to stand up, okay? I need for each of you to raise your right hand. You and each of you solemnly swear or affirm that in the case of the state of Texas versus Aaron York Dean, you will a true verdict render according to the law and the evidence, so help you God? I do. Okay. Here's what's going to happen. In just a few minutes, the indictment in this case is going to be read in open court, and there will be a plea entered to the indictment. The lawyers then have the ability to make opening statements. The state goes first, the defense goes second. Opening statements are an outline or kind of a summary of what the case is all about, who the lawyers anticipate calling as the witnesses, and what they anticipate those witnesses to testify to. The state will then present their evidence one at a time, and the defense gets to cross-examine those witnesses. At some point, you will hear Mr. Smith or Ms. Diener stand up and say the state rests. What that means is that's all the evidence that the state would have in its case in chief. It then becomes the defense's turn to present evidence if they wish to do so. But remember, as we talked about last week, the defense does not have to do anything if they don't want to, okay? At some point, you will hear the lawyers for both sides say, we rest and we close. What that means, that's all the evidence that you will hear. It then becomes my duty to prepare the set of written instructions that contain all of the law that's applicable to the case. And once I have those instructions prepared, I read them to you here in open court. And after I read the instructions to you, the lawyers will then make their closing arguments. And at the conclusion of the closing arguments, that's when you'll retire to your jury room to begin your deliberations. Okay? So now that you're even closer to me, up here in the comfortable seats, you have 2 duties. Number 1 is you have to follow the law as I give it to you at the end of the trial and throughout the trial. And your second duty is to determine the facts and the reasonable inferences that are going to arise from the evidence. The evidence that you will base your verdict on consists of testimony that comes from the witnesses and any physical exhibits that come in as a result of that testimony. Things that you can see, things that you can touch, articles of clothing, photographs, videos, things like that. The admission of that evidence is governed by rules of law, and that's where I get involved. I'm hearing the evidence for the first time just as you are. And so from time to time, I may have to ask you to step out, and I exclude you while I determine whether or not evidence is legally admissible for your purpose while I'm doing my job, just as you will exclude me once you begin doing your job. I'm not allowed to be in the jury room with you during your jury deliberations. Okay? From time to time, the lawyers may make objections throughout the trial, and the purpose of the objections is the lawyers are asking me to rule on a particular rule of law that they feel that may have been violated. And you're not to concern yourself with how I rule on those objections unless I turn and give you a specific instruction, and you will know when that happens. The opening statements and closing arguments of the lawyers are intended to help you, if they do, in understanding the evidence and applying the law. For what the lawyers say is not evidence. The evidence that you base your verdict on will come from the witness stand and not from the lawyers. You must not be influenced in any degree by any personal feeling of sympathy for or prejudice against the state or the defense in this case. For each is
These are all
entitled to
perfectly
the same
standard
fair and
preliminary
impartial
jury
consideration.
instructions for the jury.
In other words, you're to call it as you see it, okay? You're not allowed to discuss the case amongst yourselves until you have begun your deliberations, okay? But you're going to be spending a lot of time with your 13 new friends, okay? And the law does envision that you're going to talk and get to know each other, all right? But once you have begun your deliberations, it is improper for you to try and influence the deliberations with your own personal experiences. You are to confine your deliberations to what everyone has seen and heard in the courtroom and not what happened to somebody's cousin, okay? Again.
So only the evidence in the
stay away
courtroom
from me.
and the legal arguments in the courtroom.
I
That's the
hope
whole
you can appreciate,
gatekeeping function of a
the-
criminal trial.
the, intense coverage that this case has had and will have. So stay away from that. As I told you, we generally work from 9 until 5. We'll take a mid-morning break, mid-afternoon break. And I will try to get you out of here. As I told you on Friday, we will only work half a day today due to the funeral. Now, as I told you earlier, we are also having to deal with the availability of expert witnesses. And so there may be times that we may not work at all one day because of the trying to get the experts into town. So don't hold that against anybody else. It's just the way the world is right now. But I am very aware that y'all are taking time out of your schedules, and I will work in a manner that time work is done well, okay? You know the rules about taking notes, okay? We furnished you all of the pad and everything for you. And so it is, want you to be able to feel comfortable and to do your duty.
So I've asked some of the other law troopers if they want to join.
It's ready, Your Honor.
And defense is
They
ready.
have invites. I've also asked,
you'll
of course,
stand.
Nick if he'd like to join. But it's possible Nick may want to live stream this himself. If he does, I'll probably join him on his live stream. But I'll keep you all informed about that. I mean, Nick's audience is 10 times the size of mine. So
Indictment number 1616871B.
all right,
The
Here-
name and by the authority of the state of Texas.
here's the indictment.
Grand jurors of Tarrant County, Texas, duly elected, tried, and paneled, sworn and charged to inquire of offenses committed in Tarrant County, in the state of Texas, upon their oaths do present in and to the 372nd District Court of the said county that Aaron York Dean, hereinafter called defendant, on or about the 12th day of October 2019, in the county of Tarrant, state of Texas, did then and there intentionally or knowingly cause the death of an individual, Atatiana Jefferson, by shooting Atatiana with a deadly weapon, to wit, a firearm. Paragraph 2, and it is further presented in and to said court that on or about the 12th day of October 2019, the defendant in Tarrant County, Texas, did intentionally, with intent to cause serious bodily injury to Atatiana Jefferson, commit an act clearly dangerous to human life, namely, shooting Atatiana Jefferson with a deadly weapon, to wit, a firearm, and thereby cause the death of Atatiana Jefferson. Signed the form of the grand jury. Against the peace and dignity of the state.
Mr. Dean, to this charge, you may plead guilty or not guilty. What is your plea?
Not guilty, Your Honor.
Thank you, sir. You may be seated. Does the state wish to make an opening statement?
We do, Your Honor.
Ms. Dick? Okay.
Okay, state opening. Very powerful advantage for the state. The first substantive words the jury hears are from the state. They get to frame the entire arguments.
The last words that Atatiana Jefferson heard before she died. Put your hands up. Show me your hands and prove. 5 seconds. You're going to hear that after those things were yelled at her, the bullet went through her back bedroom window, into her chest, through her heart,
She fell down, face down. And you guys are gonna have an opportunity to see and hear exactly what happened next. She says, oh my God. And then the next thing that you're gonna hear, that Tatiana heard, the last noises she ever heard. Well, her 8-year-old nephew, Zion, his cries. Because when Atatiana Jefferson, just 28 years old, died in her bedroom, face down, she was not alone. Her 8-year-old nephew, Zion, was there to watch. Now, this is not a case that deals with rival gang members shooting each other. This is not a case about a drug deal gone bad or a robbery. This is a case about a Fort Worth police officer, a stranger to Tatiana, who shot through the back of her bedroom window in the middle of the night. And she was in her home and should have been safe. You are going to hear that this is an absolute intentional act, an unjustifiable act that never should have happened. You're going to hear throughout the course of this trial from multiple witnesses that are going to talk to you about what happened in this case. They're going to hear and talk to you about what happened and how we got to Tatiana taking her last few breaths in her home. So how did we get here? What happened? So we go back. October 11th, Tatiana was killed, murdered by this defendant on October 12th of 2019, around 2:33 in the morning. So we back up to October the 11th. So October the 11th started for Tatiana and Zion very similar than a lot of other days. So you guys are going to learn a little bit about who Tatiana was. Tatiana was 28 years old. She had 3 siblings. They're right over there. Amber, Ashley, and Darius. Call himself the A-team. Tatiana's mom, Yolanda Carr, she lived in the house with Tatiana off 1203 East Allen, east side of Brooklyn. And Zion lived there too. So Tatiana, raised in Dallas, went off to school at Xavier University, graduated her biology degree. After that, you're going to hear how she came home. And in 2019, she had moved in with her mom, Yolanda Carr, off East Allen, to take care of her mom's failing health. She was also there to help take care of Zion, help raise him, because at that time, Amber was having some severe health issues with her heart. And so Tatiana was living there at that house, helping raise Zion, teaching him the responsibilities, day-to-day, chores. And you guys are going to hear on October the 11th, just a regular day, that Tatiana had taken Zion outside. He's 8 years old at this time. And let me tell you, Zion's very rambunctious and energetic, as many 8-year-olds are, right? And you're going to hear from witnesses that will describe neighbors across the street that saw Tatiana and Zion outside, her trying to teach him how to mow the lawn. So this neighbor sees Zion running across the lawn, pushing a lawnmower, trying to learn how to veg. After that, on October the 11th, they went inside and they had dinner that night. They burned the hamburgers they were making in the kitchen. So there was smoke. So both the front and the side door of this house, they opened. to let that smoke go out. Both of these doors also had storm doors, kind of like those storm doors that they'll have, it's either screen or glass. That was kept shut, but the main door, the front and the side, were open to let that smoke go. So at this time, Yolanda had been in and out of the hospital. And on October 11th, going into the 12th, she was in the hospital. And unfortunately, Yolanda has since passed away. So in that house that night, there was Atatiana and her mother. So once they go to bed, they go into Atatiana's bedroom, and you're gonna get to hear about Atatiana and what she liked to do. She was studying, wanted to be a doctor. She was working, taking care of Zion, her mother, her family. She also loved to play video games, loved to game. She would get on the computer, play video games with Zion. That's what she loved to do. In fact, her siblings would poke fun at her for playing video games all the time, just what she liked to do. So that night, Zion goes to bed. Tatiana's in her back bedroom. They're in their pajamas, barefoot, comfortable. They're supposed to be safe. But you're going to learn that around 2 o'clock in the morning or so, Zion, who's asleep in her bed, he wakes up at some point throughout the night, and he sees his Aunt Tay, which is what he calls her, is still playing video games, and she's up. So 8-year-old says, I want to play too. So he gets up and he starts playing video games with her. So they're laughing, having a good time. Tatiana and Zion had no idea what was coming. They had no idea that across the street, James Smith, a neighbor, had called the non-emergency number for Fort Worth because he noticed those 2 doors were open, that front door and that side door were wide open. Lights are all on in the house. Both cars are in the garage or in the driveway. But that's unusual for those doors to just be wide open. It's a dark, really cold night. And so when the call comes through, he calls the non-emergency number, gives them the information, tells them, when asked if the neighbors are home, he tells them, well, both cars are in the driveway, and he describes them. He says that his doors have been open for several hours. I just want to make sure everything's okay. So when this defendant and his partner, Darch, her name is Carol Darch, and you're going to hear from her. Carol Darch and this defendant go in their patrol cars, 2 separate patrol cars, show up around the East Allen area. They actually park right next to a house that they believe to be 1203. They went to the wrong house first. There was a house just down the street, kind of diagonal from where Tatiana lives. And you guys are going to have an opportunity to see maps, photographs, and hear testimony from these witnesses. So you better orient yourself as to what we're talking about. So they park next to this house inside, and then no lights, no sirens. They then go across the street, and unbeknownst to them, James Smith, that neighbor who had called, and his family.
The charge is murder.
On the street.
And reckless manslaughter is a lesser included of murder under Texas law. So that's on the table too, even though it's not in the indictment.
And the one thing you're going to learn about James Smith is he and his family own multiple houses on this street of East Allen. East Allen's a little bit of a niche inside of the east side. East Allen, the 1200 block where Tatiana and her family lived, across the street, there are multiple houses, and those all belong to James Smith and his family. Right next door to Tatiana is a old church or mosque. Okay? There's no other houses right next to her. To her left, looking at the house to the right, if you're coming outside the house to the left.
I think you need to tell a story in opening, but the story should be built around the law and the evidence, not this emotive
kind of neighbor
nonsense.
that we all want. He's the kind of neighbor that pays attention, looks out for us. James Smith has lived in this area, and y'all will hear from him and learn this for 60 years. He's kind of like the mayor of this particular street, right? He's the guy that tells you your package is on the front door. He's the guy that watches out and knows everything about the neighborhood. He actually takes a particular amount of pride. He's like the guardian of that particular area. He had called the non-emergency number before. Y'all hear about that. So he's outside along with his other family members that live in all these houses, and they're watching. They're waiting for the police to show up and pull up and check. But they don't ever see a patrol car go to the front. They don't ever see lights. They don't ever hear anyone identify themselves. What they see is two figures go diagonally across the street, go up to the front door,
Oh, this coughing.
peer inside,
Jeepers.
go to the side door, peer inside. And you guys are gonna see, they don't announce. They don't knock. They don't ring the doorbell. They don't step back and call for backup. They then go from the front to the side. They check either of those doors, those storm doors, to see if they're unlocked or locked. They then continue onto the side, walking right next to Atatiana's white car. They continue, and this defendant goes wide to the right of Yolanda's car. It's in that driveway. Darch, his partner, goes between the car, the dark car, and the house. And there's a bicycle right there. And Darch kind of hits that bicycle.
It's like a
He
TB
sides
ward.
his bicycle. It's a little kid's bicycle. And at this point, Tatiana, who's sitting at her computer desk playing video games, hears something outside. To this point, she had no idea that the Fort Worth Police Department had even been called. And so you guys are gonna learn that as she's sitting at her computer desk, she thinks, oh my God, it's your worst nightmare, right?
How would they know that? How would they know what she was thinking?
You're by yourself, and you got Zion. So she goes to her purse, gets the gun out that she owns, and she walks up to the window with her gun, and she's looking outside. She's got her gun out, she's looking outside. You guys are gonna hear from Zion, who was inside and watched this whole thing. Unbeknownst to her, the defendant, his partner, were sneaking from the right side, coming around
Sneaking.
and looking at the back gate of that backyard. The defendant then proceeds to open that back gate, flashes flashlight all around the backyard. Tatiana sees flashlights. She's now heard noises and sees flashlights. She thinks, I'm gonna have to protect us from whatever that is.
That's probably true, but I wonder how they know that.
If someone that is supposed to serve and protect. So as she goes up to the window, as she's looking outside, this defendant goes into the backyard, stands in front of the window. And you're gonna see on this body camera that he turns, something catches out of the left of his eye, something catches. He sees something, he turns, and you will hear, put your hands up, show me your hands. And I'm talking about, show me your hands, put your hands up, boom. It is not fast enough for Tatiana to process and follow the commands of an unknown stranger in the backyard, let alone fast enough for him to see anything in her hands. When you watch this body camera footage, pay attention to what this defendant says, what he does, what he doesn't do, and what he doesn't say. Because that's very important to this particular case. And we're going to watch the video over and over again throughout the course of this trial. So after this shot is fired, immediately his partner, Darch says, we gotta get in there. We gotta get in there. Dean, we gotta get in there. So at that point, they go from the backyard, out the gate, around the cars, side of the house, back to the front, through the carport, in the front, in through the front door, start going through the house, straight inside, and you'll hear Darch say, put your hands up, Fort Worth Police, starts to finally announce as they're getting through the house into the back bedroom. The entire time that that is happening, you will not hear this defendant ever say, go. He said, show me your hands, put your hands up. He didn't say drop it, he didn't say gun. And if they're about to rush into this house, he did not warn his partner that he had seen him. So they go into the house, they rush to the back bedroom, they find Zion on the bed, hysterical. Tatiana is face down. Darch immediately takes Zion from that room, takes him to the next room to get him out. Tries to calm him down. And so what does the defendant do when he gets in there and sees her? He doesn't do CPR. He doesn't put his hands over her chest to try to save her life. He doesn't do any of those things. Instead, what he does is he's looking around the room, his flashlight comes upon Tatiana's gun. When we play that video, I want you guys to listen
Unbelievable.
to the side and what he says. Looks like we got a weapon. Thank God, right? The evidence is not going to show you at any point throughout that entire video that you watched that he ever says anything about seeing a gun in her hand. And when you watch that video and you see how fast this happens, there's no way. There's no way. So after they get inside, and he is looking around, he starts playing with her gun, trying to figure out how to turn off the light of the laser, trying to figure out how to disarm it, sets it down, still not providing any kind of CPR or life-saving measures to her. And it's not until you hear at the very front, because they've called for medical help and other backup, when he hears those first few officers show up at that front door because they announce Fort Worth Police, you're going to hear him say, we're back here. And it's at that point he grabs a blanket and finally puts it on her chest. But it's too late. And it wouldn't have mattered if he would have put that on at the beginning and started doing CPR, because she had hope. So they perform life-saving measures, and they spend 20 minutes trying to save her life. They did everything they possibly could. But they could not save her. She is pronounced. It's at that point you're going to hear about the investigation and what happens after that. You're going to hear about how Darch, his partner, when all the different supervisors, the entire Fort Worth Police Department shows up out there at the scene, that Darch does what's called a walkthrough of the scene. This is something that is done in police shootings. So she goes through and does a walkthrough. Here's where this happened, here's where that happened. She does not do that, though, until she gets the benefit of having her fleet attorney there. When I say fleet attorney, I don't mean these two folks, not criminal defense attorneys, but attorneys that are provided to law enforcement by the associations. They get the benefit of having that attorney show up and be with them right after the shoot. So she does a walkthrough, explains what she has seen, what happened, what she remembers. She's put into a patrol car, and then she is taken to the major case unit, which is a part of Fort Worth Police, and they investigate police-involved shootings, any incidents involving police. So the major case department has that particularized knowledge and training, and they handle these cases. So they did their own investigation. They interviewed Dart 2 different times, went through what happened. They looked at that video over and over and over again, frame by frame, slowed it down. They met with multiple witnesses, medical personnel, went out to the scene, crime scene is gonna testify. They're gonna talk to you about what they did out there at the scene. You're gonna see a bunch of different photographs so that you guys can really see and envision this house and this backyard. They took measurements. They collected the guns from both Caitlin from her house and from the defendant. And you're gonna hear that after Major Case interviewed all of those witnesses, reviewed the 911 calls, the video, looked at all the photographs, were out there at the scene, that they determined that there was sufficient probable cause for an arrest warrant affidavit to be given to a felony district judge, just like this judge. And that judge signed an arrest warrant for this defendant to be arrested for murder.
I think that's improper.
At the conclusion of this case, after you hear.
She's using the arrest to suggest guilt. He's still presumed innocent.
You listen to that 911 call and look at those photographs. You watch that video as many times as you need to. Thank God we have it. After you look at all of the evidence in this case, you will be sure, beyond a reasonable doubt, that this is murder. You're gonna know that this is not self-defense. This is not a circumstance where they're staring at the barrel of a gun and he had to defend himself against that person or to protect against his partner.
I guess we'll see.
The evidence will support he did not see the gun in her hand. This is not a justification. This is not a self-defense case.
So the state's argument is he didn't see the gun.
Your home is supposed to be the one place on earth that you get to go to be safe, to seek shelter, to seek refuge. But for Atatiana Jefferson, her home was not her refuge. It was not her sanctuary or her safe place. It was her demise. And she left in a body bag because of what he did. And so we're going to ask you to hold him responsible because that's what the law and the evidence demands. Thank you.
All right, so that's the
You wish to make an opening statement, or was yours the right?
We do, Your Honor.
Mr. Brissett.
And please report. Yes, sir. Ms. Diener, Mr. Smith, members of the call.
Miles Brissett. That's Miles Brissett,
Members of the jury.
defense attorney.
On the night of October 11th, my friend Aaron Dean never thought he'd be putting on his Fort Worth police uniform for the last time. Nor did he ever think he'd be here today before you with the charge of murder. He started his shift like he did every other Friday night when he was working. He's a young officer working a deep night shift, 8 to 6. Checked in a little early, 7 o'clock hour. As that shift went on, during the middle of his shift, he's assigned a call, the call that we're here to talk about today. And as he goes through that call, he gets to the backyard. And as soon as he and his partner go in the backyard, they're immediately presented with a situation that they have to deal with. As soon as Aaron enters the backyard, he sees a silhouette in the window. Aaron sees that silhouette in the window, and that silhouette has a firearm.
Oh, so
That silhouette has a firearm with a green laser mounted on the front rail of that firearm, pointed directly at Aaron, closer than me to you to the window.
well, so much for the state claim that he
Aaron
didn't
has
see a gun.
air conditioning unit to his right, a gate and obstruction of a fence to his left, and his partner is butt cheek to butt cheek behind him. He has no place to go. He takes a half a step back, gives the commands as part of training, draws his weapon for the first and only time right then, and fires one shot. And tragically, Atatiana Jefferson is killed as a result of that. How did he get there? That's the question. Remember from Vordaer, we start having to talk about the calculousness of reasonableness in this case. So that's what we're really talking about. Was it reasonable for Aaron to do what he did? That's the test for police officers when they use deadly force. It's an officer's worst nightmare around the world to have to draw their weapon and use it in defense of not only themselves or for others. So we have to start looking at what Aaron knew at the time. What did he know at the time? What data was given to Aaron at the time he responded to this call?
This is much stronger than the state open.
This case is about facts and not emotion. You can have all the grandiose opening statements about emotion and words and everything else, but we have to get back to the facts. So let's start with James Smith. James Smith enters the stage in this case when he makes a non-emergency call to Fort Worth Communications. Let's talk about Fort Worth Communications for a second. The state at the end of their opening said it was a 911 call. That's common for both tables. We'll probably slip up at the end. It was to the non-emergency number. Fort Worth Communications is based over just behind TCU on the west side of Fort Worth. It's a large room that has multiple stations. Each station can receive calls. One day you may be a call taker taking non-emergency numbers. You may be at the same shift if they got busy taking 911 calls. Everybody's trained the same. Everybody sits at a console that's identical. That's the call taker role. When you call Fort Worth, whether it's non-emergency or 911, they're all trained, and collectively they're all trained in the county together so they can cross over if there's an event. If somebody loses communication, say at Arlington, Fort Worth takes their calls. There's a very robust system for that. Mr. Smith calls the non-emergency number as a result of what his relatives have seen throughout the night. The doors have been open since 10. These glass storm doors that the smoke's being let out of have been open since 10. He calls, and as a result of what the communications officer hears, the call taker picks what code in the system to place upon a call. It could be a welfare check. It could be an open structure. It could be a robbery. It could be anything that they call the police department for. When we start talking about stuff like this, they follow general orders at communications. They have a playbook. This is what I'm being told from the caller. How do I code it to get officers there? Based on what Mr. Smith said to the communications officer. Not what he thought he said, not what he told the media several days later he said. What he said on that call was that it was an open structure. That's what the operator took and coded. In the city of Fort Worth, that gets coded as a signal 56, an open structure. For the police officers, they, in their patrol cars, both Officer Darch and Officer Dean, have what's called an MDC, or mobile data computer, plus the radio in the car and the handheld radio that you see on the officers that have taken you in and out of the courtroom here, and you'll see throughout the common gear. So they have their computer, they have their handheld, and they have their car radio. When the city of Fort Worth cuts an officer loose on a call, it's simple. They give them the call through the MDC, and they give it to them over the radio in case they're not in their car at the time, so they can hear them. Officer Dean was the primary officer. You may hear a Fort Worth officer during this trial say he was the sheet officer. He was assigned to, it was his beat. He's the primary, Darch is his backup. For open doors, why do they need two? Because in Fort Worth's general orders for communications, It's a priority 2 call. Priority 1 being the highest, usually lights and sirens. Priority 2 is just below it. A priority 2 call requires 2 officers. If 2 officers aren't available, the general orders say the sergeant or lieutenant on patrol in that area is assigned as the second officer. If the sergeant or lieutenant are not available, it goes to a neighboring area until there's 2 officers there. For officer safety, priority 2 call. Darch makes it there first, Dean gets there second. I think the evidence will show that Darch goes to the wrong house first. They come back, look in the squad again, and get the right address. And they walk up to the front of the address. Remember, what did they know and when did they know it?
It's all reasonableness
Here's
here.
what they're told when they're going to the call, both on the radio, for the ear, and for them to read. Complainant advised front doors to addresses open. Both the neighbors' vehicles are in driveway. White sedan and dark colored sedan. Neighbors are usually home, but never has door open. The word welfare is never said. They're given a signal 56. It's not a welfare check to Dean and Darch. The doors are open. That's what they have as the data elements when they arrive on scene. In addition to the communications general orders, the city of Fort Worth has a rather extensive set of general orders for officers. Communications is called Play 56. Play 56, Signal 56, takes them to a certain section in the general orders for how officers, young officers that have just come out of training, been to the academy, had this book drilled into them day in and day out. Signal 56 is an open structure. You go to that in the book, it says treat it like a silent alarm. Burglary of a building, a silent alarm. Silent alarm, you don't park in the front of the building or structure or residence. And I think Officer Darch will make that very clear to you when she testifies. She did to the detectives that were asking her the questions. You don't park in front for officer safety. So they park down the street on Mississippi, short distance away, and walk up. Silent alarm says you don't reveal your position. You check to make sure if there's any forced entry on the structure. And in fact, as it tells you what you're supposed to do, the unit in charge of the call shall inspect the structure to determine if there's any signs of forced entry. Any signs of forced entry. It doesn't say just on one side. It doesn't say that you just look here and stop. Those officers walk up to the front door. And at that point, you're going to see Dean's body camera come on. When they looked inside and saw the mess that was inside the front of this residence, through the front door, you see the living room. Through the living room, it's kind of a living room combo kitchen. Upper cabinets in the kitchen are out, open, stuff strewn all over the floor. The living room looks like it's been ransacked. You're going to hear from both Carol Darch and others that went out there what this scene looked like when they were there. That's a data element for these two. These two see a house that to them appears to be ransacked. We're on a signal 56. It's treated as a silent alarm. They have to be quiet. They're not knocking on the door because that's not what the rules tell them to do. And they see what to them, what Darch is going to tell you, looks like a burglary in progress. Because the house should never look like that in their mind. That's what this looks like inside. They go down the side, they have to step over a weed eater. They have to step over a mower. Data elements that may sound simple to others, to an officer that works the beats in this area, this is a neighborhood in transition. Mr. Smith and his other neighbors have worked hard to get the criminal element out of their neighborhood. yet it's still a rough neighborhood. The mosque, church next door, the air conditioning units have a 10-foot fence and a steel cage and concertina wire and steel cage fencing around all the first floor windows. Miss Jefferson's AC unit has a steel cage welded around it, and it's new construction. Things that are left outside at night tend to disappear. Burglars tend to leave stuff piled up to take away if there's a burglary in progress. You walk over a weed eater, there's a mower out at 2 in the morning. There's a young man's bicycle out down the left side. They clear the vehicles because that's what they're trained to do at the academy. They split. Carol down one side, Aaron down the other. They meet at the gate. This gate opens up to the out, it swings to the left. It's about 8 fence panels wide is this gate. Hinged on the outside, opens and swings. It's an odd angle when you look at it. When you open the gate and come through, you're immediately confronted with a window on your left. And that's the window we're talking about. It's a rather large, spacious backyard, brand new fence, brand new structure really for the most part. Something that I don't think you would expect when you see the photos for this part of the neighborhood as the community's bringing the neighborhood back. Darch goes into the right, Dean goes into the left, they're covering each other. You're going to hear from Darch that they start what they call slicing the pie. As they're covering each other, they start working the backyard in sections to make sure there's not a threat. Darch has Dean's back, Dean has Darch's back. Dean has to clear the open window he passes. Because after the door on the right-hand side of the structure up front that was open, there's no other windows for them to clear prior to getting to the backyard. Following their general orders for what a signal 56 is, go see silent alarm. Silent alarm says you inspect the structure for forced entry. Dean comes across that window. At that window, he sees a silhouette. He doesn't know if it's male or female, doesn't know the racial makeup of the silhouette. He sees it, he sees the green laser and the gun come up on him. He takes a half a step back, gives a command, and fires his weapon. After the shot's fired, they call out. Depending if it's radio traffic, both of them key their mic at the same time. The first one that keys wins. Only one broadcast goes out. You can hear it from Dean's body camera, what they're asking for, a supervisor and MedStar. Darch tells Dean, you got to get in there. We got to get in. Dean tries to go through the window. That's his first reaction. They go in, they clear the house. They get inside, and Dean does find the weapon. He moves the weapon away. In training, Dean and Darch are taught to move the weapon away from anybody that's been involved in a critical incident. It's part of their training. When Dean moves the weapon away, you'll see the green laser emitting still from it on the camera. The same green laser that was pointed at Dean, and in turn pointed at Darch's back. Because if Dean steps out of the way, then it's his wingman that gets hit with the laser. It'd be painting her back. It's true from what the state just told you that her injuries were incompatible with life at that point. Darch took the little boy all the way outside, and you're going to hear from a sergeant, the state calls her, who is her officers, it's her scene. Sergeant. She runs that scene, and there's an officer that's given custody of the boy and takes care of him like it's his own. Young Zion's a brave man. They start a process, as the state told you in their opening. Everybody from the mayor's office on down is notified. One of the people that's notified in this case is of particular interest to y'all. Her name is Lindsay Dula. And Lindsay's specialty, she's nationwide known. Lindsay's specialty is interviewing children. Lindsay's specialty is interviewing children that have faced traumatic events. And Lindsay is called in to the place where she works called the Alliance for Children. And the Alliance for Children is a place that is set up for audio and video recording. It's a safe place for children. It's a safe place to record children and interview them. So somebody that's professionally trained in interviewing a young child can interview somebody and get the information at one time. There's viewing rooms. There's observation rooms. Lindsay primarily does this for cases involving crimes against children. But there was forethought by the sergeant at the scene and the lieutenants and the captains that showed up to bring in the crimes against children or CACU units to assist with this. Young Mr. Carr is taken to the Alliance for Children. And Lindsay Dula interviews him. And I anticipate that you're going to hear from Mr. Carr probably even this morning. And there's some key takeaways I think you're going to hear from him. One, he recognizes the Fort Worth badge. And when Lindsay's talking to him, he knows it's the male that shot, not the female. So we start to talk about and see what was seen from the inside, from the eyes of an 8-year-old. And he'll tell you, he acted it out for Lindsay, hopefully he'll tell you here, that his aunt raised the gun up and didn't do what the officer told her to do. Because the camera doesn't catch everything. The camera catches what you can see from Dean's left shoulder. Back to those data elements. What did Dean know at the time? And what did he do with it? They interviewed Darch, Officer Darch, Major Case does. Carr's interview's over at 5:30 in the morning. Darch's interview's over at 7:07 in the morning. So before the rooster crows 3 times, they knew, they being the government, pretty good idea what took place out there. That gun was relevant. Everybody in Texas, everybody in the United States has the right to defend themselves in their home. This is a tragic accident. That gun was placed in the line of a police officer. A green laser was placed on the officer. That officer considered that to be deadly force against him and reacted accordingly. And tragically, Ms. Jefferson lost her life. You're going to be charged, and this court's charged at the end as to whether or not that act by Aaron was reasonable under the definitions that the judge gave you. We ask you to keep an open mind about this week. It'll go into next as the evidence is brought forward. And as you're looking at the evidence in the sterile courtroom, it's what did Aaron know at the time, not after the fact. Once the shot's fired, we have a different story. Okay? There's no doubt in my mind that Ms. Jefferson was a great person. The law requires you, when you consider a use of force shooting like this with the police, is what did the officer know at the time that was it reasonable? All the stories that have gone on post that.
I don't like his hands in his pockets like that. That's not a good look.
We look forward to you having this case at the end. Thank you. Thank you, Judge. Yes, sir.
State of Texas calls Zion Carr. Zion Carr.
This is the 8-year-old nephew.
Now, Coach, we can absolutely. Young man.
Charges murder, reckless manslaughter would be a lesser included, so it's automatically in play as well. Murder is good for 99 years. Reckless manslaughter is good for 20.
Good morning. Okay. Raise your right hand for me. You solemnly swear or affirm testimony given this cause to be the true whole truth and nothing but the true self you got. Okay, have a seat right here.
So for murder, the state would have to
Okay, there's a
disprove
rule in
self-defense.
effect, okay, that says that you can't be in court unless you're testifying. And once you have testified, don't tell anybody else what you testified to, except the lawyer, okay? Okay. I want you to tell me your first and last name and spell it for my court reporter, please.
My name is Zion Carr, Zioncarr.
Mr. Smith,
Zion, could you say your name again just a little bit louder?
Zion Carr.
Okay. You want to approach the witness, Sean?
absolutely.
Why don't you move that clip up just a hair? There you go. That's good.
Zion, how old are you?
11,
And do you remember your birthday?
July 25th, 2011.
July 25th, 2011. What's your mom's name?
Amber,
And does your mom have any sisters?
she got 2,
And what are your mom's sisters' names?
Ashley and Atatiana.
And does your mom have any brothers?
She got 1 and his name is Adarius.
I bet you that microphone is going to pick up what you're saying, so you don't have to lean over, but thank you for trying. Zion, do you know the difference between a truth and a lie?
Yes, sir.
So if I was to tell you, I'm holding up a marker. What color is this marker?
Red,
And let the record reflect, I'm holding up a red marker. If I was to tell you this marker was blue, would that be a truth or a lie?
lie.
Is it good to tell a lie?
Yes, sir.
What happens when people tell lies?
They could get in big trouble.
You get in big trouble for telling a lie. So can you promise me that everything we're going to talk about today will be true things?
Yes, sir.
Thank you, Zion. Zion, what's your favorite sport?
Basketball.
And who's your favorite basketball team?
The Grizzlies or the Lakers.
Who's your favorite basketball player?
John Morant.
I'm sorry?
John Morant.
John Morant? Why do you like him the most?
Because he's a new player, but he act like he's not. He got good confidence too.
Good confidence about them to play hard.
Yes, sir.
What grade are you in right now?
6.
You like school?
Yes, sir.
What do you like about school?
My teachers,
And what do you like most about your teachers?
they treat me well and they show me how to do problems if I don't know how to do it.
You have a favorite subject in school?
Math,
Why do you like math so much?
because I like doing multiplication and division.
What do you want to be when you grow up?
An NBA player,
Do you have a backup plan in case you're not an NBA player?
a scientist.
Oh, a scientist, that's a great job. Well, Zion, I want to talk to you this morning about your aunt Atatiana. Is that okay?
Yes, sir.
What did you call your aunt Atatiana? Did you have a special name for her?
Ain't Tay.
Aunt Tay. And did you used to live with Aunt Tay?
Yes.
And when did you live with Aunt Tay?
When she moved in with my granny.
And does your granny have a different name?
Her name is Yolanda.
Yolanda. Is your granny still here with us?
No, ma'am. No, sir.
And when did she die? Do you remember?
3 months after my auntie died.
3 months after your Aunt Tay?
Yes, sir.
And so where were you? Do you remember the name of the street that you lived at with your granny and your Aunt Tay?
East Avenue, I think.
East Allen?
Yes, sir.
And why were you living there with your granny?
Because my mama wasn't doing good yet, so I had to live with my granny.
Was your mom sick?
Yeah,
And so who else lived with you and your granny on East Allen Avenue?
just me and my auntie and my granny.
Did you like living with your grandmother and your auntie?
Yes, sir.
What did you like about it?
I like how my auntie always play games and my granny take care of me.
What kind of games did your auntie play?
Apex Legends or Ream Royale.
So forget.
Apex Legends or Ream Royale.
Oh, Ring Royale. What kind of games are those? Are those card games?
It's shooting games.
And what, are that video games?
Yes, sir.
Did you get to play with her?
Yes, sir.
Do you like playing video games?
Yes, sir.
Did Aunt Tay also show you how to do different things like mow the front yard
Yes, sir.
and how to do different chores?
Yes, sir.
What other chores did she teach you to do?
It's not a chore, but she taught me how to make hamburger patties.
How do you make hamburger patties?
You take them out the freezer, put them on a pan, or put them in the oven, or get a pan and put them on there and put it on the stove and just let it sit and then flip it.
And what do you do after you flip it?
When it's done, I'll put it on some hamburger buns, put ketchup, lettuce, and pickles, and eat it.
Okay, now let me get this straight. What do you put on your hamburger again?
Ketchup, pickles, and lettuce.
And that's your favorite way?
Yes, sir.
No mustard? You shake your head
Oh,
no?
no, sir.
And no onions?
No onions.
Okay. Well, that was nice for her to teach you how to do that.
Yeah.
What other things did you used to do with Aunt Tay?
We used to go to the park all the time.
What would y'all do at the park?
Sometimes we would play tag or hide and seek or just walk around in the little park area.
Did you love your Aunt Tay?
Yes, sir.
You miss her?
Yes, sir.
So I want to go back to the night that something happened to Aunt Tay. Is that okay if we talk about that?
Yes, sir.
So before you were in the bedroom with her, with Aunt Tay, what were you doing? What were y'all doing together?
Playing video games.
Before then even, did y'all cook hamburgers that night?
Yes, sir.
Who cooked the hamburgers?
Me.
All right, did you cook them just like you told us earlier?
Yes, sir. But I burnt them
You burned them? How'd you know you burned them?
because we were just playing games. Then we just heard the alarm going off. Then we opened it. A whole bunch of smoke came out of the oven.
And were you cooking these in the kitchen?
Yes, sir.
So what'd you do after all the smoke came from burning the hamburger?
We opened up the screen door and let the smoke go out, and we were just having pen and paper and going like that so the alarms could stop. And when it was done, we went back playing our video games.
Okay, I saw you made a motion with your hand while you were talking. I'm going to kind of explain what you did so the court reporter can type it up. And you tell me if I'm wrong, okay?
Yes, sir.
Okay, so were you waving your hand in a back and forth motion in front of your face?
Yes, sir.
And were you doing that to show how you were waving the smoke out of the house?
Yes, sir.
Okay. So, did you eat those hamburgers?
Hmm?
Did you eat them?
Yes. No, it was burnt. Only one of them survived.
Okay, so what'd you do with the burnt ones?
I threw it in the trash.
And what'd you do with the one that survived?
Ate it.
And what'd you put on it?
Ketchup, pickles, and mustard. I mean, lettuce.
Was it a good hamburger?
It was.
What'd you do after you ate that hamburger?
I went to my auntie's bed and played on my Nintendo Switch.
What's a Nintendo Switch? If I've never heard of it before, how would you explain it to me?
It's like a video game. It's a screen, and it got like 2 controllers on the side of it.
Is it the type of video game you play on a TV screen, or is it something you hold in your hand and the screen's in your hand?
Both.
Oh, you can take what's on your screen in your hand and put that on the TV?
Yes, sir. You could take off the controllers and, like, when you buy it, there's like a kit where you could plug the HDMI in it and take off the controllers and put the screen on it. Then you'll see it on the TV.
Were you playing it on the TV or in your hand after you ate that hamburger?
In my hand,
And what was your Aunt Tay doing?
she was playing video games with her friends.
Okay, was she playing video games on a handheld device or on the TV?
On the TV,
Do you remember what type of gaming system it was?
a PS4.
And when you say she was playing with her friends, were her friends in that bedroom with y'all?
No, sir.
Where were they?
They was in another house, but she added them to a party so they could talk to each other
How was she talking to them?
on a mic.
And was she hearing what they were saying?
Yes, sir.
And what game was she playing?
Green Royale.
Reed Royale.
Yes, sir.
So, did you end up falling asleep that night? on
No,
the
sir.
bed?
No, sir.
What room were you in while you were playing your Nintendo Switch with your Aunt Tay?
My Aunt Tay's room.
Aunt Tay's room. Were you on the bed, on the floor, or something different?
On the bed.
And do you remember what you were wearing?
Only underwears.
Were you under the covers or over the covers?
Under the covers.
Was it a little cold?
No.
No? It was good underneath the covers.
Yes, sir.
How long did Aunt Tay play video games that night?
Like an hour or 30 minutes.
Did you ever go to sleep at all?
No, sir.
Not before she heard a noise, you didn't fall asleep just for a little bit?
No, sir.
All right, so.
Stayed up late, 2:30
Did
a.m.
your Aunt Tay hear noise outside the bedroom?
Yes, sir.
What were you doing when your Aunt Tay heard that?
He was 8 at the time.
Still playing on my Nintendo Switch.
How did you know your Aunt Tay heard a noise?
Because she told me, did you hear it? And I said no.
Were the lights on in that bedroom?
Yes, sir.
And after she told you she heard a noise, what did she do?
She went to get her weapon at her purse.
Where was her purse?
Next to her table where she worked at.
Before she heard that noise outside, where was your Aunt Tay sitting? Was she at that desk?
No, she was in the middle of the room with her, she had her chair in the middle of the room playing on the game.
And so you said she went to her purse and grabbed out a weapon. What do you mean by weapon, Zion?
A gun.
Was it a big long gun or a gun that you can hold in your hand?
A gun you can hold in your hand.
And did you see her go to her purse and get that gun?
Yes, sir.
And what did she do after she took the gun out of her purse?
She just held it to her side. She didn't point it up. She just kept it next to her, on her side.
And where did she go with after she picked up the gun?
She was about to start walking to the window.
Okay. And when she walked to the window, what did she do?
I didn't hear nothing after that. I just seen her fell on the floor.
Okay, I want to go back just a little bit. Do you remember that night, after all this was over with, going to talk to a lady at a special place?
Now, him saying here that she didn't point the gun is a change from his prior testimony. So this will be
And you wouldn't talk about what happened?
impeached
Like when they took me?
Yes.
because he's previously stated that she did point the
Lady told
gun.
her everything about what happened, right?
Yes, sir.
Did you see, whenever your Aunt Tay walked towards the window with the gun, did you see her kind of pull the gun up just a little bit away from her side?
No, sir.
Now, when we talked before, you said that she did kind of pull the gun up a little bit. Do you remember that?
No, sir.
This is the prosecution pointing out that he's made prior
I just want you
inconsistent
to remember
statements.
exactly the way you do. Do you remember if she had the gun up or down?
Down.
Down. Are you sure she didn't have it up at all?
No, sir.
Okay. And how close did Aunt Tay get to the window?
I can't, I don't know how to say how far she was. I could say she was 3 feet away.
Okay. She got pretty close to the window.
Yes, sir.
Was she saying anything to you as she got closer to the window?
No, sir.
Did you hear anything as she got closer to the window?
No, sir.
Did you see something that happened?
I seen her fell on the ground.
This is actually awkward for the state because if this was an adult witness, the defense would
You didn't
destroy
see
him
a
on
hand,
cross.
badge?
No, sir.
Did you hear anything before she fell to the ground?
No, sir.
What happened after she fell to the ground?
She started crying, and then after that, 2 police officers came and got me.
Did you know what had happened at that point?
No, sir.
Did you know if your Aunt Tay was hurt?
Yes, sir.
What were you thinking?
I was thinking, is it a dream?
How did you think she was hurt?
Because she was crying and just shaking.
What happened when the 2 policemen came into the bedroom?
They seen me and they told me to get up, and they took me to the back of a police
Did one police officer take you or both of them?
Both of them.
Both of them? Are you sure it wasn't just the woman police officer?
No, sir. Like the man, he walked a little bit, but then the lady told him like to go check on her. Like when we got halfway, like right there by the kitchen, so he did.
Repeat what you just said, so she
Oh.
can hear you.
She told the man to go check on her. She go check on my auntie to see if she was still alive, and he said okay.
I guess the people in the comments saying kids can't memorize things have never been to a school play or a church play. I can assure you kids can memorize things.
Woman officer take you?
To the back of a police officer. I mean, she took me back to a back of a police car.
And when she took you to the last.
2:30 a.m.
What were you wearing?
Only underwear.
Were you cold?
This is day
Yes,
one.
sir.
Were you scared?
Yes, sir.
Why were you scared?
Because I seen my auntie crying, so I thought it had to be something serious.
Did you know what those police were doing?
No, sir.
And do you remember how long you sat in that car?
About like 5 minutes, waiting for an officer to come, wherever they was gonna take me.
Did another officer show up that you hadn't seen before?
Yes, sir.
He was different than the two that came in the house, right?
Yes, sir.
And what did that officer do with you?
He was the owner of the police car, so he gave me like a big shirt to put on. And then after that, I fell asleep.
Was that officer very nice to you?
Yes, sir.
You remember his name?
No, sir. He never told me his name.
But he was really nice.
Yes, sir.
And what happened after you fell asleep?
I fell asleep and then he woke me up, and I was at like a little daycare or foster care.
Oh, the place where the woman talked to you?
Yes, sir.
And was that woman really nice to you?
Yes, sir.
And she just explained that she had to ask you some questions about what happened, is that right?
Yes, sir.
When did you find out about what happened to your Aunt Tay?
After a couple of days, when I stayed with my mama, when she came and got me from the place,
And what did you find out had happened?
I seen she died. So when I seen she died, I went to my mama and asked her, "Is that true?"
Did you find out it was true?
Yes, sir.
How'd that make you feel?
I was very upset.
Were you upset that night
I
that
was
it happened?
I wasn't upset. I was confused because I didn't know if it was a dream and if I wasn't waking up still.
Hit that like thumbs up on YouTube, folks.
Anyone get shot that night?
No, sir.
Why don't you think you heard anything?
I probably don't just remember it, but I think I didn't hear nothing.
Did you hear the policeman say anything outside the window?
No, sir. I don't remember.
Do you remember seeing him at all outside the window?
No, sir.
That's also inconsistent with prior statements where he identified the badge.
The house that you lived at with your granny and your aunt Tay, how many front doors did it have?
Had to
And which of those front doors did y'all normally use?
the side one, the one where the car was next to.
The side door that the cars were next to, is that right?
Yes, sir.
And the other door points out to the street, right?
Yes, sir.
Did y'all ever use that one?
Sometimes if we order something to eat.
And those doors, did y'all normally keep the doors closed?
Yes, sir.
Now, because those hamburgers were burning, what'd you do with those doors? What'd you and Aunt Tay do with those doors that night?
So we forgot the front door was open and the screen door was still kind of open when I opened the window off it.
So y'all kind of open up the doors to let the smoke out,
Yes, sir.
but those glass screen doors were still kind of shut, is that right?
Yes, sir.
Those were open too?
That's inconsistent with the state's opening.
All right, we've been going a while. I want to take our mid-morning break, okay? You stay right here, okay? Y'all retired to your jury.
Mid-morning break. Lots of inconsistencies here and important facts from his prior testimony, prior statements, as well as the state's opening just a few minutes earlier. This is the state's first witness. This is not good for the state. And frankly, given the defense opening and how much documentation they have about SOP for officers responding to this kind of call,
You can step down, okay, go with Mr. Smith, hang on, go.
proving recklessness beyond a reasonable doubt is going to be tough.
Okay, just clip it back on, it's okay, I got it turned off. Okay.
We will start up at 10:45. 10:45, everybody.
Okay. Let me make sure nothing's going to be going on, and I'll fast forward past this break. Let's see. This should be about right. Yeah, I would have been amenable to a reckless manslaughter charge here if the officer had clearly violated department policy, but that does not appear to be the case. And self-defense would not be a legal defense to a charge based on recklessness. So that's the argument I would be making if I were the state here. But I think it's going to be hard. They have to prove recklessness beyond a reasonable doubt. I think that's going to be difficult. Yeah, it wasn't a welfare check, folks. That would be different. Then the cops arrived. The house looked secure. That's a welfare check. This was called in as an open structure, which is treated as a silent alarm. The doors were all open. There was objects laying around the vicinity of the house. Looked like it had been ransacked. That's a different circumstance. Oh, come on, folks.
No, because I want to put some stuff on the record, if that's okay.
Yeah, now the state has to explain away that prior inconsistent testimony. It's a little awkward. And they have to do it. They have to get in front of it because otherwise the defense will do it. And it'll look like the state's lying. The defense will do it in front of the jury. The jury's not back yet. So the state wants to get ahead of this.
Just make sure it's in her pocket.
It's not necessary that the victim here, Atatiana, did anything wrong.
All right, outside the presence of the jury, Mr. Smith, there's matters that the state wishes to place in the record. Go ahead.
Yes, Your Honor. We have just passed Zion Carr for cross-examination. In his direct examination, Zion Carr represented that he did not remember Atatiana Jefferson holding the gun up. He maintained that she kept it down at her waist. In any of the previous meetings we've had with Zion, he had not said that. He said the gun was up.
There you go.
He also stated on direct examination that he did not remember seeing a man with a badge outside the window. That is also different than what he has said in our previous meetings. We have turned that disclosure over to the defense. The this was the first time the state of Texas has heard him say that. It's not unusual for children on the stand to say something somewhat different. The state has no problem with that. It is just for purposes of 3914 and Brady. We wanted to put on the record that today was the first day that we had heard that.
Brady, meaning Brady
Defense is
material.
Satisfied.
Yes, Your Honor, and to the government's position on that, they have provided us updates throughout the pendency of this case, or if I've been met with them, updates from those notes, and we were just as shocked as we were from Anthony Texas.
All right.
And Your Honor, and this will come out later in trial, we have agreed versus versus the defense impeaching this witness. I'm going to say they still have a right to do, but we have agreed with the defense that we are going to redact portions of the forensic interview and offer the portions of the forensic interview where Zion is discussing the incident on October 12th, 2019 for the jury. But we will, this afternoon after the funeral, we will get that redacted and get a copy to the defense so we can agree on its admissibility.
That's the defense's understanding.
Yes, Your Honor, offer the original record only, and also exhibit A of it for all purposes.
Would there be any objection to that procedure?
No, Your Honor, we would join in its offering.
Okay. All right. Thank you to the lawyers. Mr. Smith, you have Mr. Carr come back in.
All right, time for cross-examination of Carr. So the change, the inconsistent testimony is exculpatory for the defense. So the state has a Brady obligation. That's a Supreme Court decision, Brady, to disclose that to the defense. They're just doing that in a formal way before the jury comes back in. And oddly, the state argued in an opening that
Come on back up.
the officer never saw the gun raised at him. That's different than what the defense opening was, and different than the state's first witness earlier testimony was.
Let the bailiff check the microphone for you, okay? Okay, breathe up a little bit on it. A little bit, there you go. Yeah, that's good.
So the bailiff's in plain clothes. I wonder if that's common in Texas. In my experience, they're typically uniformed.
You good to go? All right. Both sides ready for the jury?
Case ready.
All right, let's go. You can sit down. No, you sit down.
I turned on concealed caption. Thanks for the suggestion. Jurors coming in. The homeowner could have been entirely justified in everything she did, and it could still be a lawful shoot by the police officer. You're asking the wrong question. If you're looking at what the homeowner did, what the victim here did, as to whether or not she could have been justified, that's the wrong question. It doesn't matter. Well, I thought I turned on closed caption. Oh, I did, but nobody's talking, so.
All right, everyone may be seated. We are ready to proceed. Mr. Gill.
Thank you, Your Honor. Good morning.
That's my fault. Hang on, I got it. Now we're working.
Good morning.
Good morning.
Your name is Zion?
Yes, sir.
My name's Bob.
Nice to meet you.
Oh, he's not going to stand up. I hate that.
I was even look kind of away from the distance.
Bob Gill is the balding defense attorney here.
So you were very kind and answered all of Mr. Smith's questions for him this morning. Do you mind if I ask a few questions too?
Yes, sir.
Okay, thank you. And what I really want to talk to you about, since it's, 11 o'clock in the morning and my stomach's growling, I really want to talk to you about those hamburgers.
Yes, sir.
Are hamburgers your favorite food?
Yes, sir.
Okay, what is?
It's buffalo wings.
Okay. All right, well, I like those too. So
Ooh, buffalo
let's go
wings.
back to when
Now
you
I'm
were
hungry.
living with, Aunt Tay. Okay? And that was Grandma Yolanda's house, is that right?
Yes, sir.
And Grandma Yolanda was in the hospital, did I get that right?
Yes, sir.
And your mom was also having some health issues.
Yes, sir.
Okay. So Aunt Tay was taking care of you, right?
Yes, sir.
How long had you been staying at that house?
I really don't know. Probably when I was like 5 or 6. So like a couple of years.
Okay. It wasn't your first day there, you've been there for a while.
Yes, sir.
And so at the time this all happened, it was just you and Aunt Tay staying there, right?
Yes, sir.
And the cars in the driveway, did one of those cars belong to Aunt Tay and one to your grandma?
Yes, sir.
Okay, which one belonged to which?
The white one belongs to my auntie. The gray one belongs to my granny. But I don't think the gray one was there.
I'm sorry?
But I don't think the gray one was there.
Was there a blue one there?
No, sir.
Compared to most of the rest of the neighborhood, was that a pretty new house?
Yes, sir.
Do you know how long ago the house had been built?
Like how long it took them to build it?
Yeah, how long had the house been there? Do you have any idea?
We just got it, so like I could say like 2 years.
2 years?
Yes, sir.
Hey, Steve.
Hello.
Hey, everybody. Attorney Steve Gosney joining us from Florida, beautiful Daytona, Florida.
Is that what you did all day?
Yes, sir.
Did you go to school that day?
Yes, sir.
After you got home from school, you started playing video games?
Yes, sir.
Was there any lawn mowing work going on that day?
No, sir.
Was that the day before?
No, sir.
Did you have a bike?
Yes, sir.
What kind of bike did you have?
A BMX.
BMX bike?
Yes, sir.
You know where it was?
It was in the garage.
Did that house have one garage or 2 garages?
One.
Was there another building back behind the garage?
And no, because behind the garage it's an alleyway. Right after the alleyway there's a building. So kind of.
Have you ever cut the grass there before?
Yes, sir.
And Tay showed you how to cut the grass?
Yes, sir.
So was that your job?
Yes, sir.
How long did you have to do it?
Every time I get like 3 inches, I cut it.
Did you get a little bit of money for that?
No, sir.
And she also showed you how to cook hamburgers? Is that
Yes.
right?
Yes, sir.
You remember what time that night you cooked the hamburgers?
Repeat that again.
You remember what time that night, let me rephrase it. You remember what time that night you burned the hamburgers?
Right after I got out of school.
So, you remember what time you got out of school generally?
No, sir.
Probably still daylight when you got out of school, right?
Yes, sir.
Did you go anywhere after school or did you just come straight home?
I came straight home.
You know, when I use the phrase extended care, do you know what that means?
No, sir.
After school, did you go play anywhere at school?
No, sir.
Okay, so classes were done.
Hey, Jeff, Legal Vices, welcome.
Hey, Steve, long time no see. It's been what, 24 hours?
We got to be very, very quiet.
Is this a defendant? What has he done? He's looking like a thug.
He witnessed.
This is a child of the victim.
Aw,
Nephew.
Nephew.
I'm sorry for being so
So
degenerate.
then
Yes, you came in and just blasted it. You see there?
You say your aunt was playing video games?
Yes, sir.
Were you playing video games too?
Yes, sir.
Devices
You
ring.
playing on the same device or you playing on different devices?
Different.
That's a bad question, sorry.
My auntie was playing on the PS4 and I was playing on the Nintendo Switch.
Now, you're gonna have to help me here, because I don't know a whole lot about video games, okay? You said something about your auntie and her friends. She's playing with her friends.
Yes, sir.
How does that work?
So she gets a controller, then she go to messages, and she texts them and say, "Do you want to play?" And they said, "Sure." So they made a party chat and they just started talking.
Yeah, we'll help you.
Say it again.
We'll speak up a little louder.
So she go to messages and text them, "Do they want to play?" And then they say, "Sure." So they make a party chat and they start playing.
That voice is much better, so keep that up. Okay.
Okay.
Okay, so if I have this straight, she can send a text message to people and invite them to play with her on this game.
Yes, sir.
And they could be remote in some other house or some other town and still play the game with her, right?
Yes, sir.
Because in this electronic age we live in, she can do all that online, right?
Yes, sir.
So she said she was playing a game called Ring Royale.
Ream.
Can you spell
REALM.
Realm.
it? Realm?
Can you use it in a sentence?
That sound right?
Yes, sir.
You know, I know about it.
Nice spelling bee blast.
What's that game about?
It's like Call of Duty, but kid friendly. Like if somebody kill you, you turn to a chicken and then you can run around for 10 seconds.
This
And
is
if
like
you run
funny
around
but
for 10
tragic.
seconds, you turn
This
back
kid's a witness, right? The witness of the murder.
Yeah.
as a
Yeah.
chicken.
Well, of
You
the
have to
killing.
start another game mode.
Killing, right? Right.
Go
Yeah.
to different servers.
Alleged murder.
It's a self-defense issue, right?
Yep.
About there being some shooting involved in it?
Yeah, I'll review the
Yes, sir.
facts once they're done with this kid.
So like you could forge weapons
done with
like
this witness.
swords, guns, and you could forge shield. Me and my auntie we usually forge shields and guns because the swords is really not that good.
A lot of TB in this courtroom. A lot of coughing.
Yeah.
That game. And so your auntie and these other folks were shooting at each other on the game?
No, like it's when they join, they come as a team. So like say if it's only her, they have to do a solo match. And say if another one joined, they have to do duos. Another one trios, then a fourth is a whole squad. So that's how they do it. But if
Tarrant
you
County,
do, like,
Texas.
you want to battle your friends, you have to go to like a custom match.
And this is the trial where the cop shot the woman through the window of the house.
Oh.
So my kid
Oh, through the window. He would. Okay.
And
He was outside.
there's a controller, right? A thing you hold in your hand,
Yes, sir.
and that's how you play the game, right?
Yes, sir.
And on this controller, there's buttons you push, right?
Yes, sir.
And on the buttons, is there a button on that game, you push a button and shoot a gun?
Yes, sir.
Well, that's kind of what the game's about, right?
Yes, sir.
Shooting the bad guys? Is that what it's about?
It's not bad guys. It's just like I could say it's bad guys, but I don't know if it's really the game about bad guys.
Another team?
Yes, sir.
Team? Okay. So it's kind of a competition?
Yes, sir.
Okay, I got you. Okay. So I think you described that you were in the bed
Yes, sir.
playing on your game,
Yes, sir.
and your aunt was where?
In the middle of the floor on her chair, sitting in her chair playing the game.
When you say in the middle of the floor,
Like the middle of the room.
okay? Okay. And she was sitting in a chair.
Yes, sir.
And she was playing the game she was playing was on a TV screen, right?
Yes, sir.
Has anybody showed you any pictures of that room?
Say it again.
Has anybody showed you any pictures of that room?
The room?
Of the room you were in?
No, because I was already in the room.
Was the TV screen that she was using to play on the one that was in front of the bed?
Yes, sir.
So in that room, there was a TV screen and there were some computer monitors too, right?
Yes, sir.
She was using the TV screen, right?
Yes, sir.
So it was just you and her in the house. Were there some pets also?
Yes, sir.
What kind of pets did you want to have?
Dogs, kittens, and a rabbit.
How many dogs?
Sorry, it's kind of difficult. It's because some of them got missing and some of them died, so I couldn't count it.
So on this particular night, remember how many dogs were in the house?
There was like 2 dogs, one adult dog and one puppy,
And were there any cats?
3 kittens.
Three kittens
Yes, sir.
and a rabbit.
Yes, sir.
How did the rabbit get along okay with all the others?
Yes, sir.
Now, at the time, you described a time when your aunt was playing the video game and she said she heard something out in the yard, right?
Yes, sir.
But you didn't hear anything in the yard, did you?
No, sir.
That's what you told us earlier, right?
Yes, sir.
And when she heard something out in the yard, she said that to you, I hear something, right?
Yes, sir.
And then what did she do?
She went to get her gun out her purse.
She had a gun in her purse.
Yes, sir.
Where in the room was her purse?
By her monitors. By her table where her computers are.
Was there anything else near the tables where her computers are?
Not what I know of.
Was her purse near the window?
Like 5 feet away from it.
So 5 feet back into the room?
Yes, sir.
It was in the same room y'all were in, right?
Yes, sir.
I'll be sure. And she went to her purse and did she, was the purse up on the desk or was it down on the ground or?
Down on the ground.
And she, what she do, reach into her purse
Yes, sir.
and pull the gun out?
Yes, sir.
How did she pull the gun out of her purse?
She looked at her purse and then when she looked at it, she got it and just had it next to her.
Show us how she had it. You mind standing up?
I'll go over there.
You want to stand there or come down?
Right here would be great. Everybody.
Do we know how old this kid is?
He's 11. He was 8 at the time of the event.
Wow.
That's
That's
cute.
rough.
Cute as a button, though. Boy.
Make sure we have everybody. Thank you.
Huh.
When she was
That's
doing
rough.
that, do you remember which way she was facing?
She was looking towards the window.
Is gin tonic there on the stand?
How many windows did that room have?
One.
So if we say the window's pretty clear which window we're talking about, right?
Yes, sir.
Is that the window where she said she heard something in the
Yeah.
backyard?
Yes, sir.
And you said she was looking out in that backyard?
Yes, sir.
And you were looking out in that backyard too, weren't you?
No,
Well, what were you looking at?
my Nintendo Switch.
So it didn't capture your attention at all? It's your aunt You heard something in the backyard, pulled a gun out of her purse?
No, because at first she told me it might have been a raccoon, and I thought it might have been a raccoon too. She told me it might have been a raccoon, so I'm like, there's nothing I should care of.
This is the defense cross
You ever tell anybody
of this
that
witness.
before about the raccoon? Never told anybody about that before? Is that right?
Yes, sir.
Don't shake your head, answer yes or no.
Yes, sir.
To be clear, that's the first time you've ever said anything about a raccoon, right?
Yes, sir.
Lots of changes in his testimony here from prior statements.
While she's looking at this out the back window, what's she doing with that gun?
She still had it beside her.
In prior statements, he said she had the gun raised.
Earlier about the fact that there was after what happened, you got put in a police car, right?
Yes, sir.
And the police car that you were in took you down to a place where you sat in a room and talked to a lady, right?
Yes, sir.
And it was just, in that room, it was just you and the lady, wasn't
Yes, sir.
it?
I'll play the body cam footage again when we have a break.
No, sir.
And you started talking to this lady, and you told her who you were and how old you were and where you lived and stuff like that, right?
Yes, sir.
And you and this lady had a conversation.
Yes, sir.
And she was a pretty nice lady, wasn't she?
Yes, sir.
Did she get you some socks earlier?
I don't remember.
And that lady started asking you some questions about what you've seen.
I just can't get over how much coughing there is.
Yes, sir.
And that lady, and what you and she talked about was how important it was for you to tell the truth, right?
I don't remember.
And she went over some questions with you to make sure that you understood the difference between telling the truth and telling a lie, right?
No.
You don't remember?
No, sir.
Well, you're not one of those kids that goes and runs around telling stories, are you?
No, sir.
And you knew how important it was, the stuff that she was talking to you about, right?
Yes, sir.
She told you to make sure that everything you told her was the truth, right?
Don't remember.
She also told you and asked you if you knew that there was a camera in that room, right?
The officer was in a very confined space with the other officer immediately behind him, so instant retreat from a raised gun was not feasible.
Remember that?
No, sir.
And she told you that what you were saying, what she was saying, were being recorded, right?
No, sir. Don't remember.
And you were okay with that, weren't you?
I don't remember.
This is some pretty heavy testimony for an 11-year-old kid.
She told you
Yeah, this
that-
is an important witness. So I know that this defense is going to do the maximum on him because the jury's going to really listen to what this
she was
kid
gonna
says.
listen to what you had to say, right?
I don't remember.
And she told you that there weren't any right or wrong answers to all the things she asked you.
I don't remember.
Well, she was a pretty fair lady, wasn't she?
I don't know.
He's a good witness. He's getting to the point he's going to shut down. Child witnesses like this, you got to be real careful with because they'll just start checking out.
I mean, extremely articulate for an 11-year-old kid.
Doing great. The jury's going to listen to him, so you better be very careful as a defense attorney. You're listening to what he's saying, right? They're approaching because he's shutting down. They might
Yeah.
want to take a break.
I agree. I agree with that. I mean, it's always tough when kids are testifying like that.
This kid, and the jury's going to believe every word he says. So you don't want to. I don't think the liar tack is the right way to go. You want to say you were 8 years old, you didn't remember, you're confused, you change your memories, and if you say you're a liar, you got to have the ammo to back that up. You can say he was confused, his memories changed, he was too young, his witness perception was different.
So until this testimony right now, in all previous statements, the kid had testified that the aunt had raised the gun at the officer, for example, and he's just changing that statement now for the first time in court.
I guarantee that's the prosecutor, the female. You can tell by the aggressive face on her.
They all develop the same look.
It's sad.
Yeah, that's Ashley Diener.
Ashley,
the lead prosecutor.
There's
She
that
did the
harsh,
open-
nasty, condemning kind of look about her face. Yeah. Sad, I recognize that face.
Like you look up female prosecutor in the encyclopedia, man. That's the picture you get.
Yeah. Harsh.
Well, this is much more exciting than the Juan David Ortiz trial, which is going on in Texas at this point in time, which should be much more fascinating than this, but is not.
Ma'am, would you come up, please? Yes.
What's this?
Oh, this is interesting. Somebody in the gallery was gesticulating to the child witness.
Oh, this is a problem.
Tell me your name. Spell it for me.
Wow.
Okay. All right. I have noticed that throughout the testimony, you have been gesturing to this witness. I cannot have that. So I've sworn you in as a witness. If you will sit outside in the hallway and we will call you in when we need you.
Absolutely.
Thank you very much.
You are out.
Good
And
judge.
She's wearing like this thick padding.
Look at that judge look. Holy cow. Man, he gave him did you see the look he just shot?
Like in the other case I was just doing in San Antonio, it's 64 degrees and people are wearing like these giant parkas and padded down jackets in the courtroom. Like, come on.
Members of the gallery, there can be no coaching of any witnesses by anyone in this room. Understood? All right.
This judge has been good. There's been no drama in the courtroom, which is usually an indication of a judge the attorneys are familiar with and they're not going to push him.
And that was a solid, fair ruling just now.
And he also kicked her out and he says, we're going to question you further after the witness is done. So he's going to make sure the record's clear because that's a big problem that you can mess up a trial this way. So judge is very aware. I love that was perfect. Just the way he handled it. Didn't overly talk.
Listen, you speak better when you speak up. Okay. So speak up loudly, like you're answering a question from your teacher in the classroom. Okay. Both sides ready for the jury?
Stage ready.
All right. Remember, like you're answering a question in class, okay?
Judges, I like the judge already.
You need some more water? Okay.
Is he the first witness in this case?
He's a good first witness because he's very sympathetic, powerful for the state. So you're going to want him to testify first. I didn't see his direct, but
hit the like thumbs up button, folks. 1,200 people watching, 800 likes. The like button is free if you're watching on YouTube.
We are ready to proceed. Mr. Gill.
I've got the volume cranked all the way, folks. I can't do anything better.
What I'm hearing you say to me this morning is that you're having a hard time remembering what you told that lady. You know why that is?
Because it's been 3 years, I don't remember nothing from 3 years ago.
At some point in the 3 years, did you come down to this building and sit down and talk to these two folks over here, prosecutors?
Yes, sir.
Okay. They invited you to come down because they wanted to hear what you had to say, right?
Yes, sir.
How many times did you do that?
Read that.
How many times did you come visit with them?
Probably like once or twice.
And did you answer all their questions?
Yes, sir.
Did they play that video recording for you?
Yes, sir.
You did? You had a chance to, which video recording did you watch? When I say that video recording, what was on it?
Repeat that.
What video recording did you watch? Did you watch the one of you and us talking to the lady?
Yes, sir.
You watched a different video?
Yes, sir. Oh, my bad.
Which video did you watch?
Do I have to answer that?
Yes, sir.
Let me ask you a different question. Was the video of the camera
Incident.
the police officer had on?
Yes, sir.
Did you watch that with these two folks?
Yes, sir.
You had already seen that before, hadn't you?
What, the video? Yes, sir.
How many times?
Don't remember.
More than once?
I don't remember.
More than once?
I don't remember.
Other than before you talked to the lady, you had not seen that video, had you?
No, sir.
So the first time you saw it was after you talked to the lady you've been talking about, right?
Defense is doing good here. This is defense cross. This is pretty good.
Other than these two DAs over here, when you talked to them about this, who else did you talk to?
Nobody.
Not a single soul in the entire world. You didn't
I
talk
don't
to
like, I really don't like talking about what happened. So that's
Ooh.
why I never told nobody.
That's not very credible.
Wasn't your mom curious about what happened?
No, because she's seen the video already.
So you just haven't talked to anybody at all about it?
No.
You know who a guy named Lee Merritt is?
Lee Merritt, he's a Benjamin Crump associate.
He is a lawyer, attorney lawyer.
And he represents your family, doesn't he?
Yes, sir.
Did you talk to him about this?
No, sir.
Not a word.
No, sir.
Who passed the witness? Thank you.
Redirect.
He's a really
Yes, sir.
good witness.
For the record, I would like to say whenever the witness got down from the stand, defense, please correct me if I'm wrong, he demonstrated how Tay had the gun. His right hand was about at his belt line, his right elbow slightly bent, and his fingers were pointing down as if he held something for purposes of the record.
Defense agrees.
Generally, yes, sir.
Okay, that's what the court's recollection was.
Okay, Zion, I just got a few more questions, okay?
Yes, sir.
Now, are you sure that we watched that video, that you watched that video with me and Ashley?
I don't know.
You don't know? Never, the time that you came to see us a couple of weeks ago, what did we do?
We just talked and I drew a picture for you.
You just talked and drew a picture. You didn't have to video that, did you? And did we go to a courtroom?
Yes, sir.
What did we do in the courtroom?
You showed me where I'm gonna be at and how I'm gonna be on the mic and all that. And I seen a judge, not this judge, but a different judge.
And we talked, kind of asked some of the same questions we did earlier today about sports and things like that. Is that right?
Yes, sir.
Have you ever done anything like this before, testifying in front of a bunch of people?
No, sir.
Has it been a little scary?
Yes, sir.
Have you done your best to tell us what happened the way you remember?
Yes, sir.
You've been pretty brave today.
Thank you.
And pass the witness.
Mr. Gill.
Just briefly, Judge. So I have just a couple more questions, then you're gonna go home, okay?
Yes, sir.
When you met with, these two folks over here a couple of weeks ago, you told them something different about how your aunt was holding that gun, didn't you?
No, sir.
You told them exactly like the same way you told it here today?
Yes, sir.
That's all we got, Judge.
Mr. Smith,
No further questions.
may this witness be excused subject to any potential recall?
You may. No objection to the state, Your Honor.
Okay. If you'll unflip that microphone for me. And you can go to the back.
So this was the first witness. We did openings and then first witness
Yep.
is him, huh?
First witness.
That was a solid first witness.
I'll tell you, that's a tough witness for the defense. I'm not
Okay,
sure.
I'm going to stop a little bit earlier than noon. The lawyers have indicated to me that the next witness may be rather lengthy, and rather than getting started and having to stop, we're going to stop now, okay?
Wow.
We will start up in the morning at 9, like we did this morning.
Oh, good. I can go to sleep at a normal hour. Normal being 5 a.m.
So it's very important, don't discuss the case amongst yourselves, stay away from the media. You know the drill in the morning, okay? So if you'll follow Deputy Nicholson, all rise.
So I'm catching up here, Andrew. So
Yeah.
I'm off-
So I want to pause it there. I'll recap the facts and stuff. Before I do, however, I do want to mention to the sponsor of today's show, which is none other than our very own American Law Courses. And I have a new website for everybody. I think
I
do.
so. I know.
There it is.
Ooh,
So American Law Courses.
nice.
These are a traditional first-year law school courses taught at a law school level, but at a fraction of the cost and time of actual law school, and without the politics that so plagues law schools today. If you've ever wanted that law school experience, now you can get it on the cheap, but with all the quality of law school. Steve's just finishing up the first of our classes, criminal law, for the fall semester. I think this week is the last class, isn't it, Steve?
Yes, Wednesday. Tomorrow is going to be my last class, which is our penultimate class in the death penalty. And we have just had so much fun. It's been a great learning experience. I know that people have gotten a lot out of it. And I'm excited because I'm going to teach criminal procedure, Crim Law 2, Crim Pro in next fall. But upcoming in January, what you've got offered here, I know I can tell you, these are going to be just as good, if not better, than what we started with. And that is Brian Bellinger teaching evidence, a very experienced trial attorney, which is exactly what you want on evidence. And then
More than 200 trials, right?
Oh, he's had more trials than there's not many people that do more trials than I do. I'm board certified, but Ryan, he is amazing. So he is a great guy, a great talker, and will give you the tools to understand evidence in a way that you won't get even in law school. I think he will outdo any law school you go to. So that's how strongly I feel about evidence. And of course, you recruited property. Now tell us about property.
That'll be none other than our own Andrew Esquire, longstanding YouTuber. Most of you are probably familiar with him already. Experienced property lawyer. Will be teaching us all about how American property law is the very foundations of our liberty. Without property rights, you don't have any rights at all. Now, we are starting up in the spring semester with evidence and property. The second week of January, they start semester-long class taught very much in the law school style with an optional final exam at the end. It's about 14 weeks, so it runs for the spring semester. And right now, we're still in the pre-registration period, so you can get about, I think it's more than half off, so save more than $1,000 if you register prior to the start of the class. And you can do that at this website right here, AmericanLawCourses.com. All right. And with that done, let me kind of recap the facts here. So what we have here is it was October 12th, 2019, so more than 3 years ago at this point, 2:30 in the morning. And a neighbor of the house where the shooting took place noticed that the doors were open on the house and all the lights were on. And they were concerned. So they called the police, reported the situation. They did call a non-emergency number, but the dispatcher passed on the call to officers as an open structure, which is what they treat as a silent alarm type of situation. So by procedure at the police department, they don't announce themselves. They think it may be a burglary in progress. When they got to the house, again, the doors were open, all the lights were on, nobody was visible. There's a lot of items around the outside of the house, like and kind of like debris. But that's apparently consistent with what sometimes happens when a house is ransacked. So the officers are going around the house with their flashlights. And at one point, the defendant here, Aaron, whatever the heck his name is, Dean, looks through one of the windows into the home. And on the other side of that window is the victim here, Atatiana Jefferson, who is apparently raising a police officer towards the officer. He shouts at her to drop the gun and then immediately fires a single shot that kills her. The little boy we just saw was 8 years old at the time. She was babysitting for him. And apparently he was still awake even at 2:30 in the morning. I do have the body cam video of that. So let me pull that up so we can see it. It's just under 2 minutes long. And of course, the shooting happens at the end. There's no gore here, folks. It's very difficult really to see much of anything, in part because the officer's got his flashlight on the window, and so there's a lot of light reflecting back. But you'll hear the command and hear the shot, and then they'll show a couple screen captures of the gun that was found inside the house beside the victim here. Let's take a look at this.
Who called the 911?
A neighbor, a concerned neighbor. And here we go.
And so the woman was shot in her own home from outside by an officer who was outside the home. That's
Correct.
tough. That's tough facts right there. But let's take a look at the video, huh? You know, I might have seen this before.
Well, this was one of the arguments in the Breonna Taylor thing too, shooting through a window with blinds drawn.
There's a female officer with this defendant. Cop. She's right behind him. That's her whispering.
Put your hands up. Show me your hands.
Oh no. Ugh, I don't
Whoa,
like
that was quick.
I don't know about that. That's tough.
Show me your hands. Bang. Put your hands up. That's kind of odd.
And they're
Wow.
sneaking around. So they didn't even know she was. That's a tough shot there.
Yeah, so I mean, pretty clearly, if the woman had fired at the officer, she might well have had a very solid rationale for defense of herself, defense of dwelling against an apparent prowler.
The tough thing, and the tough look, and that's the first time I've seen that particular shot. But from the officer's perspective, though, see, this is, I mean, he's on
Right.
trial for a crime.
That's what's controlling here. It doesn't matter whether the woman would have been justified in shooting him. That's irrelevant here.
Right. And so the problem is, that to me, it could be negligent, but is it criminal?
So, and in the defense opening, they spoke at length about the standard operating procedures for the department. And apparently this sneaking around with the flashlights is how they're supposed to respond to an open structure call like this. Now we'll see whether they can back that out, in actual testimony. But that's what they set out in their opening. The defense opening is what they intended to show to the jury. If they can do that, it's going to be hard to show. The state would have to disprove, or rather the state would have to prove recklessness beyond a reasonable doubt. I think that's going to be hard to do if the officer's conduct was essentially in line with what their training was.
But in line with the training was like no announcements of law enforcement presence.
Right. Yeah.
Just sneaking around. And that was really quick. Like, I mean, one sentence, bang, and then another sentence.
Well, it doesn't matter. It doesn't matter what we think of the policy, right? I mean, we could argue the policy is a bad idea, and that would be relevant in a civil context. And of course, the department in Fort Worth, the city, are all being sued. Everyone's being sued naturally for wrongful death. And if it was a bad policy, that's where that would apply. But in terms of criminal liability for the particular officer, he doesn't get to make the policy. He's trained to do that. He gets fired if he doesn't follow the policy. If he doesn't follow the policy and something goes wrong, then arguably he's acting unreasonable and would be incurring criminal liability. So I think reasonable people can agree that perhaps this policy needs revisement, but that wouldn't create legal criminal liability for the officer.
What is the actual charge here?
Murder.
First
now, I felt much like you, Steve, when I first saw this. I thought, especially when I first thought the video, I thought, because the officer says, hey, I looked through the window, I could see the woman there raising a gun at me. So I think murder would be a hard sell if those facts can be, proven to the satisfaction of the jury, or at least argued, I should say, to the satisfaction of the jury. The defense doesn't really have to prove anything. But I thought he might be very vulnerable to recklessness. If that, searching around, sneaking around was inconsistent with department policy, then you could argue he's knowingly creating a risk of, ending up in a gunfight unnecessarily. But based on what the defense's representations in their opening, it seems like they're prepared to demonstrate that was within department policy.
Tough, because there's an emotional. There's a couple sides to this that are pro-prosecution. The emotional impact.
It's a bad outcome, right?
The golden rule aspect, which the state can't argue, but the jury will be thinking, which is, what if you were in the position? Here I am in my home, innocent as can be. I hear some noises out back. I get my gun. So there's somebody outside my window. I raise my thing and I get shot dead in my own home. I mean, so from that perspective, it's terrible, but that is not what this is. This is a criminal murder trial. So they're saying that so you have to look at it from the officer's perspective. And in that case, I don't know if there's a policy in place, like you say. I'll be fascinated to see the policy, because that to me would absolve him from criminal liability if he's following policy. What do you think? I mean, you're the expert on self-defense.
That emotional aspect you can see reflected in just the comments in the chat, right? I mean, that's what half the chat is saying, that this is, hey, what if it were me? What if we're in my house? What if I thought it was a prowler outside? And I totally get it. Also, the sense that the woman would have been entirely justified if she genuinely thought she was dealing with a prowler outside her house at 2:30 in the morning, arguably using deadly defensive force in defense of her dwelling, in defense of herself, in defense of her nephew. But the fact that she might have been legally justified in using deadly defense herself is really irrelevant to whether or not the officer was himself justified in using deadly defense. Both people can be in the right.
Right. And somebody's saying in the chat about, well, I don't care what the policy is. But see, here's the problem with that, is that police officers their job is to put their noses into places that normal citizens do not. Their job is to go and actively confront possible crime, and they are being called out to a possible home invasion burglary in the dead of night, and they protect themselves by following the policy. If they're operating outside the policy, then they're operating outside the zone of the law, but their job is to enforce the law. So the policy is what protects our officers from criminal charges like this, or should. And that's why it's very important, because we don't want officers to just say, well, I'll just go eat donuts all day. Screw you. I'm not doing my job because you're going to hold me in criminal contempt for this. Now, here's the thing also, that there's a civil side. This is not taken away from the fact that I guarantee that this family was going to get a big payday. Now, nobody wants their loved one to get shot from a payday, but from a restitution standpoint, I'm wondering why they want to push the criminal. Wouldn't you rather push the negligent homicide from a standpoint of a civil suit?
Well, of course, if you can get the civil suit's still in play, right? So if you can get a conviction in criminal court, then you've locked up the civil liability.
Yeah.
So
well, but it's been a long time, and so refresh me. I'm going to give it another shot.
Of course, the standard for guilt in criminal court's beyond a reasonable doubt, but in civil court, it's only a preponderance. So if he's already been proven guilty beyond a reasonable doubt, that's the liability for civil court.
Objection. My understanding is, though, that because I remember when we did civil stuff a long time ago, that if somebody was an intentional act, that the insurance policies have exclusions for intentional acts such as criminal action, whereas the insurance policies are there to cover negligent acts. So when you have an intentional act, that
but the plaintiff doesn't care about the insurance. They'll get the money from the city. I mean, the city has the money. Fort Worth has $10 million to pay out. Then it's the city's problem to collect from the insurance company. And the city may not be able to collect from the insurance company, right? Be reimbursed by the insurance company because it was an intentional act and the officer was their agent. That could quite well be the case, but that doesn't mean the city won't be found liable and have to, get a judgment for $10 million against them. But in any case, it just brings on the pressure. Because remember, this is a political decision, a civil settlement, right? And we're asking politicians to spend other people's money to make their problems go away. How hard are they going to fight doing that if there's already been a criminal conviction beyond a reasonable doubt at trial for this guy? They can't credibly argue that, well, maybe he did it right, so we're going to fight it out in civil court. That's not going to sell politically.
Yeah. So are you numb, Jeff?
What was that?
Are you numb?
No, I'm completely with Andrew in this. I mean, what happens between the insurance company and the police department is completely irrelevant and disassociated from what happens between the victim and the police officer pulling the trigger.
But this is only because we have the whole Ben Crump political hot potato here. If this was a normal kind of situation, wouldn't the victim's family be more interested in the insurance policy payout?
Well, I think
the family is right.
Yeah. But whether the insurance company can come back and say, well, they acted intentionally or with gross negligence.
Well, that may be the end, actually.
Normal negligence.
That may be the end of the day.
Oh, really?
Yeah.
Well, they're not going to bring that witness back in and question her about what she did coaching the witness on the stand.
They did it on camera. Let's see.
They might have done it off camera. They really wanted that. I love that judge. The way
there's the kid. Yeah, nothing happens after that, and the courtroom's empty, unless Long Crime started a second stream for the afternoon. Oh, I think the judge said at the end at the start it was only going to be half a day today. There's a funeral. So here's a curious thing: the lead counsel for this defendant died last week. He died of old age. He was 78 years old. He became very sick over the summer. So over the summer, he brought on the two defense counsel who are here today. But he died November 28th. He died about a week ago.
That's funny because the trial that I was just streaming before I came on here, the Juan David Ortiz, also in Texas, the Texas border agent that was accused of murdering 4 prostitutes. In the lunch hour on Thursday, the second chair prosecutor quit the prosecutor's office. He just said, "I'm done," and he walked during lunch of Thursday's session.
Why did he do that
in Texas? He just said, I've never worked for such a corrupt organization. And he was just done at lunch on Thursdays. there's some problems here in Texas. You got people dying, people just like quitting in the middle of a capital murder trial. This is like insane.
Well, I'm glad we don't have firearms in the hands of people who aren't qualified to hold them.
Yeah.
Yeah, none of that.
So at the start of the day, they did make a motion for a change of venue, and both sides argued it before the judge, and the judge summarily, dismissed the motion. So they were definitely not going to do that, but they went through the motions of arguing the question.
But see,
and
now
then the opening, I have to say, the state's opening I thought was very weak. It was by that female prosecutor, Ashley Diener. It was high on emotion and very, very light on law. Very, very light on relevant evidence, actually. It was things like, oh, they all loved each other and they were cooking hamburgers and they burned them. And her nickname was Auntie Tay, and, all this kind of emotive stuff that doesn't actually go to the legal arguments of the case. And I don't mind that stuff. I mean, that can be helpful color, but you still need a substantive framework of legal argument supported by evidence.
There wasn't much road mapping of where they were going, who was going to testify to what.
No, she just kind of summarily at the end said, and as we'll show you, this is murder, not self-defense. Thank you very much. It's like, okay.
Well, but this is sadly that tells if I need to go back and watch it, but the emotional argument can work for the state, and this is something that people don't understand is that that you get up there and like you say, well, I'm in compliance with the law. Prosecutor gets up there and shows the little kid crying and the victim's family, and they show wave the bloody shirt, so to speak.
Yeah.
And if you just have enough, just a little incremental evidence that would be enough that if believed would get you to the jury, then the jury makes the emotional decision and then they win. So
even though it's not supposed to work that way, but that's one of the reasons I tell people all the time, if we're obliged to put you in front of a jury, there's a greater than zero chance you get convicted regardless of the legal merit, because there's that kind of noise in the system. And prosecutors make these emotional arguments all the time. I mean, they did it in Zimmerman, they did it in Rittenhouse, especially when they otherwise have a weak case, right? If you have the law, you pound the law. If you have the facts, you pound the facts. If you have neither, you pound the table, right? We see that a lot in these cases where, especially if they're racially or politically energized, as this one appears to be. Again, the cop was a white male, the victim was a black female.
Well, can we step away from that? Because I'd really like to hear your analysis because we've been talking a lot about the case, but maybe I missed it, but I'm sure I did. But Andrew, tell me your self-defense analysis from the police officer's standpoint here. What is it? How do you put this into a justifiable use of force context from your perspective, since you're the expert here?
Well, of course.
Sure.
We have the 5 elements of self-defense. We got our totally free, absolutely free, 100% free cheat sheet, lists the 5 elements of a self-defense claim, provides a brief explanation of each. You can get this for free. I can't make it cheaper. It's just a PDF download, folks, at lawofselfdefense.com/elements. But those 5 elements, up to 5 elements, are innocence, imminence, proportionality, avoidance, and reasonableness. And the state would be obliged to disprove at least one of them beyond a reasonable doubt. If they can do that, a claim of self-defense collapses. These are the 5 building blocks of a claim of self-defense. Now, I say up to 5 elements because it's possible that not all 5 apply. In this particular case, the element of avoidance, for example, would not apply because, well, first of all, it's a police officer acting in the course of his duties. He's not going to have a legal duty to retreat. Plus, it's Texas, which is not only a stand your ground state, but it's what I call a hard stand your ground state. The jury's actually instructed that they are prohibited from even considering the possibility of retreat in deciding whether a defensive use of force was lawful. So there's no avoidance. So that leaves us with 4 elements: innocence, imminence, proportionality, and reasonableness. Innocence simply means, was the officer otherwise acting lawfully? Was he an unlawful aggressor in this fight? I don't see how the state can disprove that position beyond a reasonable doubt. He was called there. It's consistent with department policy and so forth, assuming, of course, the state can back up the claim that they intend to make that argument.
Or the defense.
Imminence. Imminence is the threat you're defending against. It can't be a past threat. It can't be a speculative future threat that might never happen. It has to be something that's either in progress or immediately about to happen. Well, the officer's position, supported by earlier statements from this kid witness,
and by the video,
was that the aunt raised the gun at the officer. That's an imminent threat. Proportionality is the intensity of the threat. Was it a deadly force threat against which you can use deadly force in self-defense? Well, it's a gun pointed at the officer. That's a deadly force threat. And then reasonableness is the one I thought he might be most vulnerable on. If you could characterize his conduct in sneaking around the home as being unreasonable, as being reckless. But again, if the defense can back it up as being consistent with policy, as they claim they intend to do, I think it would be very difficult to prove beyond a reasonable doubt that conduct consistent with policy was criminally reckless.
Excellent.
So it looks to me like on the legal merits, I mean, obviously we haven't watched the trial yet. We haven't seen all the evidence yet, but from what I've seen of the video, the openings, and this first witness, and knowing, because we had that discussion in court about the prior inconsistent statements, I think it's an uphill battle for the state on the legal merits.
Did the video show her raising the weapon? No, I didn't see that.
I can't see that in the video myself because of the glare off the window, but clearly he's shouting gun. It would be a reasonable inference that he fired when the gun was coming up. Otherwise, he just would have fired instantly without shouting about it. He claims throughout that he saw the gun coming up, and the only surviving eyewitness, the kid, initially also said the gun was coming up. So,
and this isn't
the state has to disprove all that beyond a reasonable doubt. I just don't see how they do that.
And this may not be self-defense. It could be justifiable use of force. And what's the difference between justifiable use of force and self-defense?
Good question.
Ooh,
there's a number of circumstances in which you might be privileged to use deadly force. Some of them involve defending yourself against a threat, but others might be defending other people against a threat. So that wouldn't be self-defense. That would be defense of others. The legal elements there are essentially the same, though. Just replace the pronoun, yourself with some other person. Also, there can be circumstances in which you're defending your dwelling, and there may not. It may either be presumed that you meet the conditions for self-defense because you're in the context of defending your dwelling against a forcible, unlawful intruder, or in rare cases, like in Colorado, we have the famously called a "Make My Day" statute. It's not even required that you're facing a deadly force threat before you can kill someone if they're unlawfully forcibly in your home. They need to present some degree of threat, but it can be any degree of threat. It doesn't have to be a deadly force degree of threat.
And I know that everybody's it's a lot of it's who are you sympathizing with, because everybody can sympathize with the homeowner here.
Right.
And so now the question is, there was a green laser here. Who had the green laser? Was that
that was on the woman's pistol?
And was that actually?
The officer says he saw the laser on him, directed at him, which would be consistent, of course, with the muzzle of the gun being on him.
I have a little commentary. I don't know if you want to move on from that on the child witness and some of the issues that arose in that testimony that I saw. And I've dealt with this issue on appeal, and it's really tricky with these kind of kid witnesses because there are rules in Florida, at least, that said that every police interview with a child witness must be videotaped and recorded on audio and video. And there's a three interview rule too, where the law enforcement cannot interview more than 3 times because of the danger of influence the testimony of child witnesses. So you got an 8-year-old here who's very subject, their memories are weak and they're subject to being manipulated. The case that I did was exactly what happened here, which is not the police that are interviewing, it's the prosecutor's office. So that what the prosecutors do is they bring in this witness, coach the hell out of them, and it's done outside the presence of anybody. It's not videotaped. It's not subject to the 3 witness interview rule, and that prosecutors do all the manipulating and coaching that they want. And it's invisible to the defense. Now, here's the problem from a defense standpoint. Let's assume you have a prosecutor who's doing that, and I had a case in which we had, I think, a very unethical prosecutor who's interviewing a witness, telling them what to say, coaching them, etc. How does a defense attorney ever cross that? How do you ever determine that? And this is what came up in our appeal, because what happened was the kid has a big change of testimony after he gets interviewed by the shop. So the defense wants to call the only witness to the change, which is the prosecutor. So wants to call the prosecutor as a witness to impeach the victim or to impeach the child witness. And then, of course, that became, oh, no, we're good and we're innocent and we're prosecutors and we can't be subpoenaed. And they won. So the defense is completely defanged from ability to impeach this witness after wrongful conduct by prosecutor. Now, maybe they didn't do it, but how do you ever discover this? This is a big issue in trials, and you saw it right here exactly in action.
Yeah, you see it. I've seen it from time to time as well when prosecutors overreach and essentially make themselves into witnesses by being actively engaged in the investigation, which is supposed to be done by other people, not by the prosecutor, right? There may be investigators with the prosecutor's office, but then they can be called as witnesses to testify about what they know or what they discovered about the case. It shouldn't be the prosecutor going out there playing detective, but sometimes they do that.
And then when they do it, and then it's like, first of all, defense attorneys are very reluctant to actually push the issue because they don't want to make it personal against the prosecutor because they got to deal with them in other cases. But then when they do, it becomes this major fight, and the judge thinks it's out of line. What are you doing, defense? And the defense is the bad guy for wanting to call the prosecutor. And in this case, I had a case, great judge, and the defense, wanted to call the prosecutor because how else are we going to find out why this child changed their testimony? It wasn't recorded, and we're just relying on what? We have nothing to accept its change, right? What it necessitated the change of testimony? It was the prosecutor. But then then they clothe themselves in this innocent, I'm the good guy prosecutor. BS. They need to record every interview, every interaction with child witnesses like that.
Yeah. So in the discussions, I mean, I wasn't listening closely for that issue, but they definitely had a third party, I believe, who works for the prosecutor's office, probably on a contract basis, some kind of social worker, it sounded like, with an independent facility where they recorded those first initial interviews with the kids. But then we did hear also that the prosecutors had the kid in the courtroom at least twice, where they were talking to him, and they tried to play it down like, oh, we were just showing them, familiarizing them with what the courtroom looked like and so forth. But the defense wasn't there for that.
Well, and this is the thing, for the system to work, it's an adversarial process. And so, and somebody's joking because Skosny has a bad prosecutor story. Well, but the thing is that I don't know whether the prosecutor was bad or good. I don't have any clue. But how are we to discover that? How do we ever sort out who the bad prosecutor and who the good prosecutor was if it's hidden from view? It's cloaked. Well, just trust them. I don't trust them. I've seen too much bad stuff. So it's like, what's the check? What's the check on the road? Absolute power prosecutor. That's my concern. I'm not saying that, you understand. I get it. Point made.
So let me start going through some of these super chats here. Actually, let me take a look first at the Law Self-Defense member dashboard. Folks, you can be a member of Law Self-Defense, get all your questions answered for free. No super chat money for those. And it's less than $10 a month, folks, 30 cents a day. It's a pretty good bargain. Lots of exclusive member content as well. You can become a member at Law Self-Defense right now for less than $10 a month at lawselfdefense.com/join. Or every time you pose a question you want answered, it's got to be a $5 super chat. So your call.
So exactly. If you do more than 2 super chats a month, you're wasting your money.
Right. Exactly. So let's see what we have here from our members. Let's see. Robert asks about the change of venue motion. The judge denied that. The judge appears to be pretty no nonsense. I mean, he hasn't had to do a lot so far, but often that's a sign of being no nonsense. The lawyers aren't pressing him, seeing how far they can get. Salween says, yes, seems like the state was really playing the emotional card. I would agree. Chuck says, did you get this from me on Facebook? Chuck, I did get a notification from you on Facebook about this case, but several people sent it to me. I don't remember which one I saw first. Sorry about that, but I do appreciate everyone bringing it to my attention. It was not on my radar screen, so I was not planning to cover this. Jerry says, the storytelling and description of the houses and street is very confusing. What does it have to do with the charge? I think they're talking about the state opening there. Yeah, I didn't think the state opening was very compelling at all. Eric says, Andrew, if it turns out the defendant did see the gun, is he automatically not guilty?
Automatically not guilty. It's
hard to say that, of course, but it would be consistent with a reasonable perception of an imminent deadly force threat that the state would have to disprove beyond a reasonable doubt. So it's certainly favorable to the defense.
Okay, well, go ahead. You're doing super chats, but I did want to address, like, in what circumstance that you would see a JOA being granted in this case? Can you see that happening, Andrew?
No, I mean, they're hard. Come on, they're never granted, really.
I know. So if it goes to the jury, then the emotional appeal can win.
Well, there's facts in dispute, right? So the state is disputing that the gun was raised, for example. Now they have this witness. Granted, he changed his testimony, but now his testimony is evidence that the gun was not raised. It's going to be for the jury to decide, which version of that they want to give more credence to. So there's something to argue. I mean, really, a JOA should only really be if, even if you believe everything the prosecution says, it's no rational jury could come to a conclusion of guilty beyond a reasonable doubt. But if judges see even 1% of evidence that could support a guilty verdict, they're going to leave it to the jury.
And see, this is the problem with the changed testimony of the child witness, because now the state could say, no, you didn't see that. Now all of a sudden he's changed it. Now they have evidence. She's in there with her gun and her gun is not raised at him. That's a fact question that, if believed, can go to the jury. And that change, and the state knows that that's the important point. Because if she's pointed, and so that's the kind of frickin' change that drives a defense attorney nuts, because they depose this witness, they say this is what happened, and then all of a sudden the little key fact that helps the state get it to the jury, and then they argue emotion, and the jury reacts emotionally. That's
exactly right. So, I mean, if you're a prosecutor, you're sitting around the office before the trial and you're like, this looks like a point of vulnerability for us. We better get more than 0% evidence on this point, or the charges could be dismissed in effect. So you just make sure you get it. It doesn't have to be true. It doesn't have to be real. It doesn't have to be particularly credible. It just needs to be more than zero evidence.
Like the Rittenhouse trial. Remember when the Rittenhouse trial, and they gave the fuzzy video that created the doubt on the JOA?
Pinch and zoom, right?
Yeah,
and they added pixels.
Well, that was one of my favorite things from a Russian client we did in a shipping case probably 20 years ago. It's like, we don't have this document that says this. He's like, what do you need the document to say? I'm sure we can find it somewhere. Like,
we have ways.
Don't say that to me. If you have the document, you have it. Don't say that to me. He's like, in Russia, we have.
Let's see, Eric. Jerry says, I like that the defense attorney introduced reasonableness. Yeah, because I think that's the key vulnerability here. And he buttressed it pretty well by referring to the department's SOPs, standard operating procedures, for this kind of call. Eric Beckman says, I feel like the attack to the defendant's self-defense claim is to reasonableness of anything. Like, it's not reasonable to show up to someone's house without IDing yourself. Apparently the policy was, first you search around when it's essentially the equivalent of a silent alarm having gone off. Let's see. Jason B. Too many homeowners are getting killed in their homes by police. When police are sneaking around a home at night unannounced, I think the only reasonable thing is to assume that the homeowner might come out armed to investigate what is going on. Maybe, but that's a policy decision. That's not something that's up to the individual officer. Andrew, will you be answering questions in the Law of Self-Defense chat? I'm doing it right now, man. So here we go. Let's see. RP Berm says, the issue is not how reasonable the victim is, but how reasonable was the officer. That's right, because the victim's not charged here. It's the officer on trial. Let's see. Jason B responds, I understand. I don't think it's reasonable for an officer to automatically assume the person in the house is a threat. I think they need to assume it could be the homeowner. Well, the threat's the gun. I mean, once the gun starts coming up, then, they don't have to be shot by the homeowner either. And they wouldn't know it's the homeowner, right? Someone's pointing a gun at them. They think it could be a home invasion scenario. Women are involved in home invasions too. I mean, even assuming they could identify the person as a woman. Eric says, didn't the state mention in their opening that the nephew said the aunt pointed the gun? Yeah, I thought, the state said that the officer did not see the gun. The defendant did not see a gun. That's what the state's argument. That's inconsistent with the defense narrative. So we'll have to see what evidence each side can put up. Remember, the opening's not evidence, right? So the jury will be told that.
Yeah, and just so people know, an opening statement is a summary of the facts of what the parties expect the jury should hear. So generally, we're kind of making assumptions because it's a stupid move for an attorney to lay out facts that all of a sudden are contradicted by the evidence as it comes out. Generally, you have two competing narratives that are both supported by facts. So, so when we're trying to frame the debate without having heard the evidence based on the narratives that have been presented at the openings, expecting that neither one is going to lay something out that's not going to be supported by facts in later evidence.
Right. Jason asks or says, then the officer should have waited for backup, announced he was there. The fact is he killed the person he thought he was trying to protect. They need to reevaluate their tactics. That could all be true, but that's a question for a civil case and for policy within the department, not for criminal liability of the officer. Like, departments change policies all the time on things like this, right? So it used to be by default, if there was a high-speed pursuit, the cops were chasing you until they caught you or they crashed, right? Well, a lot of departments did away with that because car accidents, innocent people were being injured in the course of these pursuits. So unless certain criteria were met, the officers, the standard changed, the policy changed. The officers were told, you don't get into a high-speed pursuit over petty anti-stuff anymore. They could change this policy too, but what controls the reasonableness for the officer was the policy in effect at the time, not what we now realize it should be in the future. Let's see. Jason, this is at least the second time an officer sneaking around killed a homeowner standing in their home.
Not more than one, not more than twice.
Yeah.
It happens a lot. I don't like that sneaking around policy either.
Jason, I guess legally the question is, can policy be unreasonable? Does following policy automatically make his actions reasonable? Pretty much. I mean, it's his boss. It's the whole department making the policy, right? Presumably they have expertise in doing that. They're a police department that's been in existence a long time. He's going to be allowed to defer to their greater expertise in setting policy. I guess it would have to be something quite insane, but you wouldn't expect that to survive in policy.
It didn't work at Nuremberg, so.
Well, that was what they were doing was quite insane.
Yeah, that's right. I don't think that's, it's interesting because, that's like, well, following the law, if the law is immoral, but this law is not, you can't say for sure immoral. It's not quite the difference between parading Jews into gas chambers, opposed to like sneaking around the house versus going back and announcing your presence. Those are tough analogies. I think those are very far apart. But but that's kind of what they're kind of trying to do here with the state.
And by the way, that's why.
Argument.
Right, that's also why these swatting activities that happen, where someone who doesn't like you calls the police, says something terrible is happening at your home, a murder is being committed at your home, some kind of domestic violence act. So the police rush into your house. Nothing's actually going on. It was all a lie. But maybe you're standing there with a gun in your hand and you get shot by the cops. And maybe they shoot you lawfully in the sense that they reasonably perceived an imminent deadly force threat. They were there lawfully. They were responding to exigent circumstances based on what they believe to be the facts of the case. And as far as I'm concerned, those people who commit those swatting calls ought to be prosecuted and convicted for attempted murder, because that's likely to be the outcome.
I agree. I was going
to ask that. What you think of? It has to go beyond just filing a false report. I mean, you have to reasonably expect that there's going to be an unfortunate outcome to that situation.
Right. Let's see. James writes, didn't seem like they tried to knock on the door or get someone's attention inside before sneaking around. Yes, apparently their policy is not to do that in an open structure call, a signal 56 call. They treat it like a silent alarm. They sneak around first.
And there are good arguments for such a policy. It's one that really needs to be fleshed out rationally and not infused with this emotional content of this type of trial. The debates on whether that's a good policy or not are independent of the facts of this case. The fact is if that's the policy and this cop's following it, then that should protect him from criminal liability, because that's what, sadly, police have to deal with very difficult situations right up front, right in their noses, and got to make hard calls real quick. And so their defense is to rely on policy.
Yeah. So there were a couple things here I didn't like about what the defense, I guess I'd say their conduct in the courtroom. Nothing big, but kind of theatrical points, really. But during their opening statement, for example, the defense, the lawyer he stood up, but he had his hands in his pockets the whole time. Looked very casual to my mind. He's defending someone who's charged with murder, go to prison for 99 years. I'd like to look like I'm more emotionally engaged in this than just standing there like I'm talking about a golf game I had last weekend. And then when the other defense attorney during cross of this witness part of the time was just sitting in his chair doing the cross. And I would stand up questioning a witness.
They were questioning the witness from the chair?
Yeah.
Are there any kind of physical disabilities the person has?
I don't know. I mean, he stood up to leave the courtroom. He's not in a wheelchair.
That's pretty casual.
Well, that was I mean, that was one of the things we saw in Brooks, though. He was shackled to the table, so in order to
Right, well,
avoid
he was the
appearance of
defendant.
bias,
Yeah.
I mean, in order to avoid the appearance of bias towards the defendant, everyone agreed that they would present their arguments just sitting down.
Yeah. So maybe it's just my Italian heritage. I like to talk with my hands a little bit when I feel something's important to talk about, and I like to stand up in the courtroom. I mean, I'm there for a reason. I'm working, right? The stakes are important. I want the jury to recognize that I don't like this kind of casual demeanor by defense attorneys, especially on a case of this importance. But it's style points. It's not really law points, but that's how I feel about it.
But style and points cannot be dismissed in the presentation, the theatrics of the defense or the prosecution, depending on which side you're on.
Hey, Freddie makes a point in the chat. He says that it may be because it's a child and they don't want to be seen as intimidating or pushing around the child. That's an interesting thought.
Yeah, but I think you can stand up and still not be intimidating. I mean, you definitely don't want to come across as intimidating for sure. That would be very important.
You know, now I think the defense, I was skeptical a little bit about calling the child a liar, so to speak. But, you know, you could say that the child is being manipulated by the adults around them into testifying in the way they want. And I think that is an effective attack because the
I
child
tried to get to that. Yeah. They mentioned the what's his name? Lee Emmett, the Benjamin Crump type character who's the family lawyer here. Did you speak to him? Of course, the kid says no, but it raises the inference, right? Did you really? The family lawyer who's suing for $10 million and you're the only witness, they really never talked to you about this case. It just doesn't seem very credible.
Well, and you know, and the thing is that this is a great case. Where did you find this one? This is a good, because the great thing about this is that if you put yourself in the shoes of the homeowner, I am completely there. I could see myself getting shot because if I heard that stuff, I'd have a gun and I'd be ready to go, you know? And then on the other hand, put yourself in the view of the cop. He's being called out to a possible home invasion. His policy says you're supposed to check it out and get, you know, not announce your presence and find out what your job is to find out what's going on, maybe protect somebody who's being held at gunpoint, right? You know, you can see yourself in both sides of this. This is why this is fascinating. A real good,
so
a good fact pattern for lawyers, but not for the parties, but for the lawyers.
Right. So say it's an armed home invasion, right? You announce yourself and suddenly it's a hostage situation.
Right.
Right. So you're looking in windows to see what's going on.
Or it's some kind of like domestic thing where a guy's got a gun and all of a sudden the cops show up and it's like, okay, then I'm going to kill the wife instead of, you know, it gets really,
it comes to murder suicide. Right.
Yeah.
James writes, I'm willing to admit the cop was lawfully justified, but to put myself in that situation leaves me uneasy to think this could happen to any of us. Should I be in my own home holding a firearm, but I may also be missing some details, especially of the cop making his presence known before the shoot. No, he did not make his presence known. I mean, not until the last second before the shoot. But he wasn't required to. In fact, he wasn't supposed to, apparently. Let's see.
But see, now this is why I go back to the charge, because I don't see how this could be a first-degree murder charge. This has got to be some kind of negligent homicide.
No, it's first degree. First degree. No, reckless.
It's overcharged.
Reckless manslaughter is a lesser included of first degree under Texas law. So, of course, murder is a first degree felony. It's good for 99 years. Reckless manslaughter, I'm sure the jury will be instructed on reckless manslaughter. That's a second degree felony, good for 20 years. If I were the state, I think I would have focused more on that, frankly, except if they've looked at the policies and the cop was 100% inside those policy boundaries, I think it's going to be tough to get to recklessness. So if you're just trying to make an emotional argument anyway, you may as well go big or go home, right?
Yeah, but that's unethical prosecution. But it happens all the time. But I mean, I think that I think it's overcharged from what I'm hearing about this case. They should be going, what you should do is you should charge what you really think describes the situation. You don't play these extortion games where you say, well, if we're going to make a BS argument anyway, let's throw it up all the way. And then we get a compromise, we win. I mean, that's garbage. That's not what a prosecutor should do. They should follow the law. If they should charge the maximum that they think is provable. And from these facts, when you see the defense, I don't know. I'm very skeptical. How can this be first degree murder? To me, it's a negligent type homicide at best. But I don't know. Maybe I'm missing something. I mean, what's the theory
I mean,
by first degree murder?
And how could you get there? I guess if the evidence was, say the woman was not armed, there was no gun present at all inside the house, right? Then it would look sketchy as hell, because how could he have reasonably perceived a deadly force threat? They don't have that because the gun was found inside the house. Even the kid says she kept the gun in her purse, right? So they can't dispute that. But they're trying to say, well, the gun was never raised. Well, if the gun was never raised, should he have waited longer before firing the shot? What was it actually already an imminent deadly force threat, knowing that it could be a homeowner in the home? I guess is the argument they would make. And that's what they're trying to do. That's why the kid's testimony changed, presumably, from his earlier statement saying, yeah, I saw my aunt raise the gun, to now, nope, she kept it by her side the whole time. And the state themselves had to point out, outside the hearing of the jury that, oh, Your Honor, this is the first time he's saying that. Every other time he's spoken to us, he said the gun was raised.
But see, the problem here also is that not only, I think, is it not ethically correct or not proper within the role of the prosecutor's office, I don't think it's good tactical strategy. Because, like, for example, the Casey Anthony case, I think the Casey Anthony case was overcharged. And the reason they got a not guilty, if they had gone for a negligent homicide, I think they would have had been much stronger grounds. But instead, they're going for this first-degree murder intentional homicide, which was never provable. But they're playing this game of like, well, we're going to threaten you, we're going to charge you with the highest. And then they end up losing the whole thing because they've overcharged it. And that you could see that here also.
Let's see. Richard writes, geez, I can't wrap my head around sneaking into the backyard and shooting through a window in a second and calling that okay. And listen, I don't mean this in a negative way, but that's an emotional response to the bad outcome that happened here. The cop's making decisions in the moment, right? He doesn't know about the burned burgers, that this is some kid's aunt. He's seeing a gun raised in his direction, according to him.
And of course, nobody's saying it's okay. We're saying it's not criminal.
It's a tragedy. There's no question about that. This woman did nothing to deserve getting shot. She was not a bad actor. It's terrible that this happened.
But it's like a car accident. I mean, some people get in a car accident and 2 people died, right? Well, that doesn't mean it's criminal. It means it's an accident. Maybe there was negligence. Maybe there wasn't. Maybe it was just an accident and somebody died. And it's a tragedy. We're saying, well, I can't believe you're sitting there saying it's okay for people to die in a car accident. We're not saying that. We're saying to put a cop in prison for this act is a very high burden for the state to prove.
I will say that there seems to me to be a continuing problem, and this is a policy training issue for the police, a continuing problem with the commands that officers give. They're just not well thought out. Sometimes we have scenarios where you have multiple officers shouting commands to a suspect, and they're different commands. And when the suspect complies with one command, he's being non-compliant with another command, and he ends up getting shot by the officer with whom he's being non-compliant. Even though, as far as he's concerned, he's just trying to be compliant. Or in a case like this, where the suspect has a gun in their hand, and you say, "Show me your hands," the suspect may be raising their hands to show you their hands. And the gun comes up with the hand, and then you shoot them. As opposed to if you said freeze or drop the gun or something, then raising the hand would be inconsistent with that command, right? But it's like these commands are given out in kind of a panic mode. They're just mouth noises as opposed to things that you actually would want, if you'd given a thought, would want the suspect to comply with. You see a gun in someone's hand, do you really shout? I mean, "Show me your hands" is not the right command, right? I would think, but it's
reach for the sky. Well, gentlemen, it is now 6 a.m. here in Korea, so I think I should probably get at least 3 hours sleep before I go to work.
All right, Jeff.
So.
Hi, Jeff.
for joining
Always
us.
fun, man. Great to
This is
see
a
you.
fascinating case. I'm going to go back and watch the opening statements and see how that goes, because this is a really fascinating issue here, the issue of self-defense as it relates to this case. I have to go back and find out what. Well, you said the prosecution's opening wasn't really that dynamic. What about the defense's opening?
The state opening was emotive, but not very substantive, and very, very quiet. She kind of whispered the whole thing too, which I thought was kind of odd.
What
and the
defense?
courtroom's very poorly mic'd, so it can be quite difficult to hear anything. The state argument I thought was much more substantive, but again, kind of casual. Hands in the pockets, and I would have had more energy, I think, if it were me doing it. But other than the demeanor aspect, I thought it was a very sound open for the defense.
Well, I'll have to go back and watch them during my day tomorrow. But thank you for inviting me on. And Steve, it was great to see you again after a whole 24 hours and about a 48 for Andrews. y'all take care and have a great day with this.
I love
All
it.
right,
It's
Jeff.
good to see
Thanks.
you, Jeff. You're always
We'll see
great
you
to
soon.
see you.
Bye, guys.
I love Jeff.
Hey, Steve, I should mention, I had not planned on covering this trial. It'll certainly still be running into next week. Particularly, it'll be running this Thursday, I would expect. This Thursday, I have a medical procedure, so I won't be able to live stream the case on Thursday. If you were available and wanted to do it, I'd certainly hand the hat over to you. If you can't, I don't know, maybe, I know Nick Requeta is traveling today, but if he's back, he may want to do the case. But I'm going to try to just plant seeds in people's heads who might want to live stream the case on Thursday, because I'll definitely be out.
Maybe we should get Legal Vices to do it. I'd love to, but I'm going to be on Megan Fox. I have 2 interviews set up. I'm going to interview Megan Fox, and I'm going to interview Steve Hayward. Do you know Steve Hayward of Powerline blog? He's a professor.
Okay.
At
I know
UC
him
Berkeley.
by name, and
he was
reputation.
he's actually on the back of my book. He's one of the
awesome.
he's one of the endorsers of my book. Now, he's a great, brilliant conservative scholar out of UC Berkeley, and I'm going to interview him on my Rumble channel. Although I haven't figured out how to do this live stream thing. I would love to, and I thank you. And when I figure out how to live stream, I will be there. But in the meantime, I'm just going to do these interviews. But Jeff should do it, man. He's got that terrible trial he's doing. I don't know how he found this one. This one's fascinating. I love this trial. This is cool.
Yeah, this looks pretty good. Yeah, the one he has is awful, but this looks pretty good. Let's see. Robert says, Andrew, will the defense be able to put in the video of his prior interviews? Yeah, I expect what they'll do is they'll call the social worker who conducted the interview, and they'll play the video recording as part of her testimony. Would be my expectation. And Chuck says the strategy of bunkering in your house and making the intruder come to you is tactically valid on, and then his comment ends. So, yeah, I mean, okay, I guess
I don't think the homeowner, did the homeowner do anything wrong here?
No.
I mean,
No.
what if the homeowner actually did point the gun at the person outside that they didn't know who it was? Would that be a mistake?
Then the question would be the reasonableness of their perception. You know, someone sneaking around your house with a flashlight at 2:30 in the morning. You're a woman alone in the house with an 8-year-old kid that you're babysitting. I don't think it would be.
But you point the gun when you're not willing to fire. I mean, this is kind of that muzzle discipline question. You're in your home.
We know that, but a jury's not going to know that. So
I'm just thinking outside the box a little bit,
Right.
I'm just trying to think, did the homeowner do anything wrong?
No. Nope.
Yep.
I mean, not criminally wrong. I mean, we can all set, quarterback.
Like Monday morning quarterback, right?
Right. Monday morning quarterback, things that might have been done different, like step away from the window so you're out of sight of whoever's out there with the flashlight. But she's got no legal obligation to, have no sophisticated defense tactics. All right, let's get to the super chats. Let me refresh this page to make sure I'm up to date on those. Remember, folks, hit that like button on YouTube, please, please, please. That's the most important metric that YouTube uses. All right, Jensen, $10 super chat. Thank you very much. Asks, he should have gone to the door for a wellness check, according to Fort Worth DP. That's SOP. This is a local news issue for me. Yeah, but the media, the local media, has repeatedly reported this as a wellness check. It wasn't. It was an open structure call, which they treat as effectively a robbery and burglary in progress. Not a wellness check. A wellness check is when you show up, all the doors are closed, but a neighbor said, hey, we haven't seen them in a couple of days. Can you knock on the door and see if they're doing all right? This was a neighbor calling saying, hey, the house, all the doors are open at 2:30 in the morning, and we're afraid bad things might be happening. So it's a different code. And the defense in our opening was very specific. This is the code that the officers got to go to. It was not a wellness check, even though the media has reported that 1,000 times. So that's, of course, what the general public is going to remember forever, is that this was a wellness check. That's factually untrue. Jensen again, $5. See, for that, you could have been a law self-defense member. For that first $10 super chat, you could have been a law self-defense member for the whole month.
Maybe she is.
Well, then she's paying me more in super chats. Then I would have answered the question in the law self-defense member chat.
Okay.
But thank you very much, Jensen, for another $5. Writes, we'll say murder is a bit much, too early to tell, but manslaughter might be an appropriate charge. Yeah, we talked about that already.
But
Michael,
this is on the super chat thing and on your platinum membership, because the thing is that nowadays I don't even have cable anymore. People used to, my mom, old mom, I'm sorry, she's not that old. She's 88. Is that old? She still pays $200+ a month for cable.
Yeah.
Now, the thing is nowadays people will watch you and to cover trials, and just, you can get all the entertainment you would ever need just from, and you learn something, and
a lot more legal expertise than you'll get off a law and crime.
and you get to interact, and we'll answer your questions on when you sign up for these memberships. It's like, okay, well, do I really want to? But think about all the benefits that you get, and it's basically a lot cheaper than one cable channel, the cheapest basic cable channel coverage, right? So support where the good content is. That's my point.
A little more than $0.25 a day, folks. We all have a little bit of change rattling around in the car. Okay, let's see. Where am I? Michael Hickson, $10. Thank you very much. Is there any other charges with the case besides murder? Do we have another felony murder type deal? It wouldn't be felony murder, but it would be reckless manslaughter, which is, I actually have the statutes up here, as a matter of fact. Let me see. I thought I pulled them up. I do. Let's see. So he's charged under, let me make this a little easier to read. He's the indictment, the formal charge against him is under Penal Code 1902, which is murder. The relevant part here is a person commits an offense if he intentionally or knowingly causes the death of an individual, or intends to cause serious bodily injury, or commits a felony. That would be the felony murder provision. But he clearly intentionally shot her. So unless it can be justified, it would be murder. Self-defense would be the legal defense there. But also included as a lesser included. So for folks who don't know, if you're charged with a crime, many crimes have lesser included offenses that are very similar to the one charged, but are missing one or more elements of the higher level offense. So if a charge has 4 elements that the state has to prove beyond a reasonable doubt, but they only prove 3, you're supposed to be acquitted of the charge that requires 4, but there might be a lesser included that only requires those 3, and then you can be found guilty of that lesser included offense. Here, that lesser included offense would be manslaughter under Texas law, which I also have someplace. Let's see. Oh, yep, here. So murder was Penal Code 1902. Manslaughter is Penal Code 1904. You commit manslaughter if you recklessly cause the death of an individual. Murder is a first-degree felony, so 99 years max in Texas. Manslaughter is a second-degree felony. That's good for 20 years max.
You said, what is the jurisdiction again? You said the county, but what's the city?
Fort Worth.
Okay, so it's a big city. Because this is the thing. I think this is a big city type case too. I don't, I don't feel that this would be tried in a rural area.
Yeah, and right. So it's a big city with an urban center, racial division and all the stuff that goes along with that.
Right. I mean, I don't know. I have a lot of, it's a terrible fact scenario, but not everything is criminal. This is the problem, is that everybody wants to say, well, you're justifying. No, I'm saying that it doesn't meet the elements to be punished for criminally. Civilly, maybe, yes. Civilly, the city is liable. The damage, it was a wrong. It was a tort. Absolutely. People are entitled to compensation. But you're talking about punishing this police officer for basically destroying him for the rest of his life. For what? For making a mistake in a very high pressure situation?
Even if he's acquitted, he quit being a police officer, 2 days after this happened. He's been waiting the last 3 years to see if he's going to spend the rest of his life in prison. Folks, you don't get married and have kids if that's a possible fate you're looking at. So his life has been frozen, and of course he'll never have the life he had before. So it's changed even if he is acquitted.
Right.
Let's see.
Tough situation. I mean, it's a tough situation all around. I'm just saying you can visualize yourself on either end of this one.
Yeah. But even for the reckless manslaughter, you have to show the recklessness. And to the extent his conduct was consistent with his training and policies, it's going to be difficult to prove recklessness beyond a reasonable doubt. Levi the welder, $5. I'm a little behind, but prosecution pushing the emotional angle so hard means the facts are against them. They're feeding into the bias to get a conviction. Seems quite likely. That certainly was my sense. Kingslayer Damocles, $5. So a state actor interviewed this child with no attorney or parent present. It better be taped or it's untrustworthy. Yes, I believe it was taped. We'll get all the details of how the child was interviewed, but there's no suggestion by the defense, at least, that it was inappropriate.
Well, but then there's that we bring up the issue about the prosecutors interviewing the witness multiple times without, and those are not taped.
Right. Yeah. Rowan Coerts, $5 super chat. This is for you, Steve. Says, Steve, I sent you another email about run and gun match.
Oh, gosh.
Also
Yes.
proves I'm not some kind of weirdo or troll by sending this. Branka shamed Steve into a shooting match. Well, you should go, Steve. You should go. Shooting matches are fun.
You know, see, all you guys are so much better. You met my friend Chris. He's an expert on the firearm and an AR. You, my friend, are an expert on the gun. I am a plinker. I've run and gun, man. I'll tell you, I'm not one of those guys, but I appreciate, actually, he's been very nice. He sent me a lot of nice things and invites to go and shoot around in the woods and stuff. But because I do have, but I'm definitely all pro self-defense. See, this is the thing. I mean, if somebody was creeping around at night like that, I'd have my gun in hand in my house. And I don't see that I would be behaving any differently than this woman was. So it's a very tough fact scenario for me to say the officer's justified, because I don't like him creeping around like that. I think it's bad policy. But on the other hand, I can see myself, I feel bad for the officer. I really, this is one of those hard fact cases,
Red Ronin, $10, says, here in El Paso, the DA resigned. She was supposed to work on the case of the Walmart shooter, and during her time in office, she never bothered making any motions. Now she's under investigation. I'm not sure I know which one the Walmart shooter is. There's so many cases in Walmart. I wouldn't know which one it is.
Which one is that? Which Walmart shooter? There's the guy that gunned down like a bunch, but he killed himself too. It couldn't be that one.
Levi the welder, $5. This is for Jeff. Jeff is gone, but I'll read it. It says, sorry, I left your stream, Legal Vices. That case was boring as sin and looked like the outside of a Home Depot. I have to troll you over here as well. And finally, John Lee Pettimore III, $20. That gets 2 ka-chings. Back in the early 90s, there was a cops episode from Fort Worth PD. The cops looking for a burglary suspect and comes out. And he comes out with a big ass Colt. Oh, some old guy comes out with a big ass Colt to see what the commotion is about. The PD could easily have gone south. Yeah, I mean, it may not even be, what if a neighbor just sees you sneaking around with a light around somebody's house and they come out to intervene on their neighbor's behalf. Now you're getting shot in the back by someone else acting in, what they believe is reasonable. Let's see. I think that may be it, except for one that just came in. Let's see. Tony Badalamenti, $5. Thank you very much, Tony. Why are you giving the cop a pass on failing to identify the target? Don't you need to distinguish homeowner versus intruder? No, you just need to identify a threat. You don't need to know the property rights of the person who's threatening you. If someone's trying to shoot you with a gun, you can defend yourself against that. If you're not yourself an unlawfully acting bad actor, which of course the cop is saying he wasn't. He was there dispatched in the course of his duties.
It's kind of tough though, because there is let's look at it a different way in this thing. There is another choice. I mean, that cop could have dove out of the way and retreated. He did not.
Well, the defense says, the defense in their opening suggested that was not practical. That there was an obstacle to his right, an air conditioning unit or something. There was an obstacle to his left, and his partner was immediately behind him. So he couldn't go anyway in any direction.
Yeah, these lawyers think everything.
Yeah. But of course, you'd want to offset the prosecution from making that argument, right? Because if I were the prosecutor, certainly I would say, hey, did you really have to shoot her? I mean, wasn't there something else you could have done that didn't involve taking a human life? It's tough though. I mean, if someone's pointing a gun at you, we don't really dodge bullets.
And police officers go through tons of training to respond fast like this. I mean, because
Right.
these things happen so quickly and so fast that the hesitation was what gets you killed. So, all of that, all of us second guessing Monday morning quarterbacking is counteracted by tons of police training that goes into when this happens, you respond. When somebody pulls a gun, like I don't know if you've ever seen the police shooting where the guy goes into his truck and he gets himself a rifle out and pulls it out.
Right.
And,
I have. Yep.
and it's a horrific case.
And every
it's
cop has seen that video too.
Every cop's seen that video.
Yep.
It's like when as soon as this happens, this is when you respond. So they are trained very specifically to respond the way this guy did. Although from a homeowner's perspective, I don't like it one bit.
Yeah. Bad outcome. No question about it. All right, folks. I think that's it for the trial. I don't have any more to add. Steve, why don't we plug your book as long as you're here? I've got my first edition.
Let's plug like everything. Let's plug everything.
All right, this is Steve Gosney's book. Steve, tell us about it. Oh, look who wrote the foreword. Look at that.
What's this guy here? Look right over here. Wait a second. Andrew Branca. Look at that. Attorney Andrew Branca forward. This is the new improved second edition. Oops, there we are. That has an extra chapter, an upgraded cover, upgraded pages, and is available now. Because this is the only place I ever make any money is selling a book. So please buy the book. It's chock full of powerful information. If you want to get an information idea what it is, go to crimelaw.net. It will tell you about what's in it. Buy the book. I'd appreciate it. And I'm going to be down. I think I'm going to be down. We have to coordinate all this. Nick on his cell phones. He's, whether it actually happens, I don't know. But my wife and I are going to Miami, and we're supposed to meet up with Nick on Tuesday to say, and I might have some books with me. I might be able to sign them. I might be able to sell them to you. So if the moons align, it might happen. And then the other thing I want to promote is something I think you want to promote also, which is the second class in the American Law Courses program, which is being taught by my buddy Ryan Bellinger, who's a great trial attorney, who's going to have loads of good information and practical stuff, no PC, no political correctness. And that is the AmericanLawCourses.com. And I'll be teaching criminal procedure next, like in the fall of next year. But upcoming in January is evidence and property. Property there.
Taught by none other than Andrew Esquire, who many of you will know from his own very popular YouTube channel and Law Tuber Experiences.
His law sub is what? Legal Mindset?
Legal Mindsets, right.
Yes. And
all right, so folks, and we're still in the pre-registration period for the spring. So you can save half the tuition if you register now for either the evidence or the property, or if you register for the whole bundle of courses, you save a lot more than half. I forget exactly how big the discount is, but then you get every course in the curriculum that we're currently offering. And Steve is just finishing up criminal law for the fall semester, and the response we've gotten from the students has been overwhelmingly, ecstatically positive. So I'm sure you'll have an absolutely fantastic experience with all these courses.
And also, if people would go by my Rumble channel and sign up, I'm almost at 2,000 subscribers on my Rumble channel. So if you can't get enough of Gosney, there's more where I talk about all kinds of stuff that's non-law related, music and philosophy and religion and all kinds of parenting and all kinds of topics. So yeah, just go to Crime Law with Stephen N. Gosney at my Rumble channel. And hopefully when I learn how to live stream, Andrew's going to come on. Aren't you, Andrew?
Yeah, sure. I'd be happy to. Absolutely.
Okay, but I got to figure out how to live stream. It's tricky.
All right, folks. So for me and Steve both, I'll do my usual closing. Remember, if you carry a gun, so you're hard to kill. That's why I carry a gun. That's why Steve's got his share of guns. So we're hard to kill. Our families are hard to kill. And you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. Until next time, Steve remains Steve Gosney. I remain Attorney Andrew Branca for Law Self-Defense. Stay safe, everybody. And where's my little closing jingle? Here it is. Take care, Steve. I'll talk soon.
Bye-bye.